Enrico, Enrico. Good morning, Chair.
Morning, Senya. How are you?
Good morning, Chair.
How are you?
Chair, can you hear me?
Yes, I can hear you. I want to check whether you can hear me. Can you hear me?
Good morning, Chairperson.
Morning, Ambassador.
You know, this advertising of Cape Town being lower in load shedding is not real. I have less load shedding in Joburg than I have in Acacia Park. I'm sitting through load shedding once again.
Oh.
Chair, good morning.
Yes,
Chair,
Shanya, can you hear me?
yes, now I can hear you. Please note that I have to leave by 11 because I've got a flight to catch.
Oh, yes. No, it's understood. I hope by then, let's see how far the department can take us to in their response.
Okay, thank you.
Yeah.
I just want you to know. Thank you. Bye.
Bye,
Chair,
Senya.
I will have to leave by 12 to go to mosque.
Okay, Ambassador. Well, I don't think it will be long because we I suspect we might have to finalize this next week, Tuesday, Wednesday, after we have received the C list from the department.
Okay.
I mean, from the Parliamentary Legal Office and the State Law Advisor.
Thank you, Chairperson.
Thank you.
Apologies, I only saw your message after the proceedings.
Yes, Ambassador. Yes, because it's always good when one of us is in the house, but is able to present our report or our yes. No problem, Ambassador.
Because I'm using temporary gadgets because I had a bit of a challenge. I was robbed of my gadgets. So I'm yeah.
That's unfair. In Gauteng.
And in Cape Town.
Oh.
I must go and find a very, very good traditional healer.
Exactly.
Saturday.
I know you must come to my you must go Botswana in the Kalahari district.
Absolutely. On Saturday, in front of the PCO, I think we were targeted, not only me, but two other persons were targeted as well.
Okay, Ambassador. No, as long as you are safe.
Yeah, but Cape Town was an accident. I was driving down Jake's Carnival with my bag at the bottom, and they broke the window and took the bag. So all my bank cards are gone, passport gone, gone.
Yeah, that's unfair. Huh?
Yeah, so if I'm not feeling so good, understand why. It's a bit mental.
Exactly, Ambassador. No, I understand. Thank you.
Okay.
Recording in progress.
Chairperson.
Morning, colleagues, our committee staff, and also the delegation from the department, our stakeholders, the PMG, but also our communication team and our public at large. Allow me to take this opportunity to formally open this meeting of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure. The purpose of today's meeting is to consider the negotiating mandates on the expropriation bill from our provincial legislatures. What will happen, we will receive a presentation by the secretary just to take the committee into confidence in terms of what is the negotiating mandates of the provinces. And then thereafter, we will then allow the departments to express their views in relation to the proposed amendments. And then once that is done, we'll then allow the parliamentary legal office to express a view in terms of what is their take. But understand that the C list is still work in progress, and anticipating that next week to be finalized, then we'll be able to then vote on those proposed changes. Having said that, is there any apology that the committee secretary would want to table?
Thank you, Chairperson. Yes, we do have an apology. The apology is from Honorable Khaye. He's attending the Joint Standing Committee on Financial Management of Parliament, and he says he will join after that meeting is concluded. That is the only apology, Chairperson. And
Thank you.
To confirm members who are in the platform, it's yourself, Chair, Honorable Mushodi, Honorable Dango, Honorable Boshoff, Honorable Mama Rekhane, Honorable Lond, and Honorable Landsman.
Thank you, Committee Secretary. Let's also table the apology from Honorable Boshoff. She has a flight to catch at 11. The Ambassador Dango at 12 is attending the mosque. But I hope by then we would have covered a lot of ground Without any waste of time, can we then allow yourself, Committee Secretary, just to table before the Select Committee the overview of the provincial legislature mandates? Over to you.
Thank you, Chairperson. I'm not sure whether Enrico will be able to assist in flighting the document. Let's go down, Enrico. Let's go down. Yes. No. Number two. Let's start with on number 2. Thank you, Enrico. Chairperson, good morning, honorable members and colleagues, officials from the department, and everyone in this meeting. Chairperson, the negotiating mandate from the provinces, it is tabulated in this document on how they have, voted, or how they are mandating, their permanent delegate to vote. So, Chairperson, I will start with the first province, which is the Eastern Cape. The Eastern Cape P8 says, the province vote in favor of the bill with proposed amendments, and therefore mandates the permanent delegate of the NCOP to negotiate in favor of the bill. Free State, the Portfolio Committee on Public Works, Infrastructure, Roads, Transport and Human Settlement, as designated by the Free State Legislature, proposed the following amendments to the bill. They vote in favor of the bill. All the amendments are stated in the document. Gauteng Provincial Legislature votes in favor of the subject to they vote in favor of the subject to the amendments being considered. KwaZulu-Natal, the Portfolio Committee on Public Works met on Monday, the 13th of November 2023, and agreed to mandate the KwaZulu-Natal delegation to support the Expropriation Bill, B23B 2020, with the consideration of the amendments. Limpopo, NCOP permanent delegates to negotiate in favor of the bill with the proposed recommendations. Mpumalanga, the Portfolio Committee on Public Works, Roads and Transport, Community Safety and Security and Liaison, after considering the Expropriation Bill B23B 2020, confers on the permanent delegate representing Mpumalanga province in the NCOP a mandate to negotiate in favor of the bill without any proposed amendments. Northern Cape, the committee supports Expropriation Bill B23B of 2020. Northwest Provincial Legislature vote in favor of the bill. Chairperson, that's how the mandate, the last one, Western Cape. The Standing Committee on Infrastructure, having considered the subject of the Expropriation Bill B23B 2020, NCOP referred to the committee in accordance with the Standing Rule 217, confers the Western Cape's delegation in the NCOP the authority to not support the bill with the following recommendation. The recommendation are in the document. Thank you, Chairperson.
Thank you, Committee Secretary, for tabling the negotiating mandates from My apology from our non-provincial legislatures, and having outlined every tabled and giving the overview of the provincial mandates, the negotiating mandates. So I just want to check if there's any point that members would want to raise. What we will then do, yes.
Yeah, I'm not sure if I can be recognized. My name is Alan Fuchs. I'm from Gauteng.
Okay. Yes. Because
Chair,
we wanted to allow the departments to then respond directly to all the proposed amendments that were made by the provincial legislatures.
Yes, Chair. If we could just display that slide again, which shows the mandates of each of the provinces.
Okay.
And I would like just to refer to what is written there regarding Gauteng.
Okay. Committee Secretary.
Chairperson Enrico, can you flag the slide again?
It says the Gauteng Provincial Legislature votes in favor of the bill subject to the amendments being considered.
Chair, it's just the wording of that particular phrase. The last
Yes.
word "considered," okay, is in my understanding not what was agreed, and in fact it should be changed to approved. So the amendments proposed by Gauteng need to be approved in order for Gauteng then to support the particular bill. Thank you, Chair.
Chairperson, if I may come in, I
Yes,
will have to revert back to the chairperson and the committee upon this particular issue. I don't know if Honorable Fox is speaking for the entire committee and speaking on behalf of the committee and is mandated to do so. Can Honorable Fox please indicate?
Can I suggest that Mr. Dangor speak to the legal advisor who drew up that particular report? She will give him a very clear view. Thank you.
Thank you. No, great.
Thank you.
Thanks for that interface between the ambassador and the focus on the matter. Can we then give the platform to the department to respond to speak to the proposed amendments by the legislatures? You'll guide me, Committee Secretary, who's engaging or leading that aspect from the department?
Good morning, Chair. I am Masiro Maake. I'm the DDG for Policy and Regulation in the department. Our delegation comprises of myself, Mr. Ndo, there is Mr. Mukwena. Then we have Advocate Naidu, who's going to deal with the responses.
Thank you, Mr. Maake. Advocate Naidu, the platform is yours.
Good morning, Chairperson and members of the committee. Thank you very much. Chairperson, I'd like your direction on how you'd like me to proceed. Would you like me to go through the table and discuss the department's comments on each item in the table, or would you propose a different method?
Yeah, I think that the correct approach will be for the department to speak direct to the proposed amendment from the legislatures.
So work through the table.
Yes.
All right. Mr. Chairperson, might the technical assistant put the table on screen? It would be helpful for everyone to follow the text.
Oh, brilliant. Enrico, can you help us? Or they can even give you a sharing rights, Advocate Naidu, so that you are in charge of the
All right.
of the slides. Yes.
All right. I'm trying to share. There we are. Thank you, Chairperson. I believe I am on screen sharing.
Yes, yes.
At the outset, I should say that some of the provincial legislatures have common comments, and if I respond to comments from one of the provincial legislatures, I'll simply indicate later on if that's been repeated elsewhere, so as not to duplicate.
It will also be important to indicate whether you share, you agree with those proposals, and where you do not agree, can you also indicate that?
Yes, thank you, Chairperson. I believe one of the members has a question, Mr. Chair.
Let's okay. Honorable Bratiseth.
Yes, Chairperson, and I thank you for your indulgence, Chairperson. I'm sorry, I had problems with signal, and this was an issue I wanted to raise before we started going through the clause-by-clause issue. And I do apologize, and you are welcome to rule me out of order. But I just want to raise the issue before we start this process, Chair. The representative of the department is with us now. After the department delivered a document to the committee where they commented on the various inputs from the various stakeholders. And the department themselves said that it would be advisable and strongly recommended to have a further interaction with the banking sector. And the last time I raised this, Chair, you kind of pushed me away saying, well, that's just a comment from a stakeholder. But I think the department is more than a stakeholder, Chairperson. The department is a major player in this entire thing, and we rely heavily on their recommendations. And I'm concerned that on the altar of urgency again, the altar of the headlong rush to try and get stuff done by the end of this calendar year, we are ignoring a very important recommendation from the department. And I just want to know when we're going to fit that recommendation in and have that further interaction with the banking sector before we finish these negotiating mandates and before we ask the provinces for final mandates. That is a recommendation from the department. I do not believe it's a recommendation that we can just ignore. For whatever reasons they have recommended a further interaction with the banking sector. So I don't know if you yourself or maybe representative of the department can comment on that, but I do think it's vital before we go to final mandates that we have that interaction. Thank you, Chairperson.
Thank you, Tim. Mr. Make, is it the position of the department? Because I thought that was not the position of the department, that we must consult further with the banking sector. I think Mr. Make is better positioned to explain that.
Chair, the issue arose in the context of
somebody's trying to speak.
Somebody else talking.
Yes, you can continue, Mr. Make.
I was saying the issue arose in the context of I was saying the issue arose in the context of the submission when Mr. Advocate Nadu was making his presentations on behalf of the department. Will it defeat the purpose of this sitting if Advocate Naidu goes on with his presentations? Then we can take an adjournment at a later stage and then revert back to you before the conclusion of this session.
No problem. Is that I thought Mr. Advocate Nadu was not expressing the view that given the unfolding process, we cannot proceed without necessarily having further engagement with the department. I mean, with the banking sector. My assumption was that because all the stakeholders, we gave them an opportunity to make oral representation. They made their written representations to the select committee upon our invite, and in his response to this, to the oral representation by the stakeholders, I thought that was not in itself to say we cannot proceed forward. But if that is the view, let's allow yourself and Advocate Naidu to sort it out. Let's allow Advocate Naidu to present, and then you'll come back to us. Thank you. Is that okay, Honorable Brother?
Yes, Chairperson. I'd simply wanted to flag it because my recollection, and I will go and check back in the document, was that it was a recommendation. And I can contribute to that discussion later, but I have no problem with the suggestion of doing it later. Thank you, Chairperson.
Thank you, Honorable Brother. You can continue, Advocate Naidu.
Thank you very much, Chairperson. I will consult with my client, and once I've taken instructions, we will revert regarding further inputs from the banking sector and agricultural sector, if any. The first comment relates to the general objects of the bill, and it comes from the Gauteng Provincial Legislature. There are 3 points, really. The first is whether indirect expropriation should be covered by the bill. Secondly, whether the expropriation of property for nil compensation should be limited to government-owned land, where compensation has already been paid because the land was previously expropriated. And the third is, I beg your pardon, whether nil compensation should be limited to government-owned land. And then the next issue is whether expropriation of already expropriated property for a different purpose should be subject to nil compensation. I have delivered written advice on the nature of indirect expropriation, so I will simply outline some of the points without going into very much detail unless you request it. Indirect expropriation is the unwitting or unintended consequence of some kind of regulatory act. It is not the intentional taking of property by the state for public purpose or in the public interest. And because it is unintentional, it does not fit with the idea of a bill which is all about the procedure, substantive rules and procedure which are meant to regulate intentional takings of property. That's not to say that indirect expropriation might not be recognized in our law. It's simply to say that the scope of this bill is to deal with direct expropriations of property. So if that's the starting point, indirect expropriation is probably not appropriately regulated in this bill or at this juncture. It may be more appropriate to have a different piece of legislation to deal with indirect expropriation, or even an entirely different chapter in this bill which can be formulated in due course. The fact that indirect expropriation is not regulated under this bill, I don't think poses an insurmountable obstacle to the bill passing, subject to the other concerns that I raised previously, which don't relate to the distinction between direct and indirect expropriation. Chair, the explanation of why indirect expropriation might or might not be part of our law is set out in this table. I don't propose to dwell on it unless members have questions at this juncture, which I will take through you, Chair.
I think you can proceed, Advocate.
Thank you, Chairperson.
Yeah, let's continue taking into account the fact that there are members that will be leaving at 11, others will be leaving at 12. So just gallop through the response of the department to this proposed amendment from legislatures. Thank you.
Yeah, yes, Chair. I will canter instead of galloping in case there are points that need clarification. These are difficult legal points, I must say, so I wouldn't want to compromise on substance. The next point, is nil compensation something to be limited to government-owned land? If one takes a step back, I think the more fundamental question is, does the Constitution permit nil compensation in the first place? And the answer is yes, provided it would be just and equitable, having regard to all the factors that are listed in section 25.3. Whether nil compensation should be limited to government-owned land as a possibility, and by implication to no other land, is something for the committee to decide. If the committee adopts that approach, it would mean that any other land could not be expropriated for nil compensation, but it doesn't follow from that other land could be expropriated for nominal compensation, provided it's just and equitable to do so. The third issue is whether the expropriation of already expropriated property, albeit for a different purpose, should be compensable. And it's a really interesting question, because I think it depends on who the expropriatee would be. If property has been expropriated and it vests in the state, and that state organ is not using the property for the intended purpose, it may be possible for another organ of state to request transfer of that property to it to use for its own purpose. That wouldn't necessarily entail an act of expropriation. It could be an intragovernmental transfer or an intergovernmental transfer. The bill is designed to govern situations where private property is taken away, not where public property is transferred among organs of state. Where property has been expropriated and then transferred in the public interest to a private person, and that private person is not using the land for the intended purpose. For instance, let's say property was expropriated for land reform purposes, for residential use, and the recipient uses the property for an unauthorized purpose, not using it for farming, for instance, but decides to put up a hostel or a hotel or run a bar, or use it for commercial purposes, or even lease the property out to somebody else for profit, then it may well be just and equitable, or rather it may well be in the public purpose or in the public interest for an expropriating authority essentially to re-expropriate that property, to take it back from that person, so that the property can be used for a legitimate public purpose or in the public interest. And if compensation has already been paid to that individual, There may be circumstances in which it would be, from the expropriated individual, there may be circumstances in which it would be just and equitable to add to the amount of compensation depending on the purpose of the re-expropriation. Or, as a matter of policy, Parliament could say, we're drawing the line here. You've been compensated once and for all once before, and there really is no need for further compensation. As to compensation of the person who was using the property for an unauthorized purpose, if that person received the land for no consideration, then there really is no need to compensate them. If that person paid some kind of nominal amount for the benefit, then it would be a question of justice and equity whether that person needs to be recompensated. These are quite complex issues which turn on sets of facts. I've just mentioned 2 sets of facts, but there may be more. It may be that the person sought to be expropriated is a business, and that business might have gone bust. And some of the factors to consider in whether compensation should be paid to that business are the circumstances in which that business went bust and how those relate to the land itself. It's not possible to give a comprehensive answer, but as a matter of principle, whether compensation should never be paid or should always be paid is something that I'm hesitant to adopt an absolute position on. I think it would always turn on the circumstances. I hope that answer suffices. It's a bit of a lawyerly answer, but as I've illustrated, it isn't possible to be categorical about these things. The KZN provincial legislature has raised a few points, and I've responded to some of them in the table. The first point is whether there needs to be some kind of investigation before a decision to expropriate is taken as to the nature of unregistered rights in the property, and whether that investigation needs to be done by an independent body. Well, the bill currently provides for a mandatory investigation of all rights in particular property. And in the case of land, formal rights will be registered, but there may also be unregistered rights like customary rights. It's incumbent on the expropriating authority to do its homework and to identify all relevant rights, which would then weigh in the balance in its decision as to the suitability of the property for expropriation and the amount of just and equitable compensation to offer to all affected persons. That's the expropriating authority's job. The bill does not provide for an independent party to make that assessment. The recommendation requires an explanation of what independence is. Broadly, independence means financial and operational and institutional separation, separate functioning from the administration. Those are the hallmarks of independence. It doesn't appear to me that an independent body needs to be established under this bill to conduct that kind of inquiry. If it were to be established, it would entail a substantial and substantive amendment, and it would require lots of safeguards to be put in place to guarantee independence. And it seems to me that that's over-egging the pudding. What are the KZN provincial legislature also asked that the nature of unregistered rights be listed in the bill. It's rather difficult to do that because it might be a very long list. And if the bill were to enumerate all the kinds of unregistered rights that notionally could inhere in land or in movable property or any other kind of constitutional property, there is the risk that it might be under-inclusive. Let's think of some examples. As far as land is concerned, there could be an unregistered pledge. Land could have vested in another person by acquisitive prescription. There may be rights held under customary law. And of course, there's such plurality in the kind of customary law in our country, different systems of law. As far as, I beg your pardon, pledge would relate to movable property, not immovable property. But again, that's another example. There may be other rights, unregistered rights in movable property. It could have been leased out like a car. It could have been hired. And so whether there are particular unregistered rights in a case of expropriation should be answered on a case-specific basis. It would depend on the nature of the property and the nature of the relationships that people have developed to that property, or with that property, rather. So I don't recommend that the committee attempts listing the nature of unregistered rights in the bill. Should women, households headed by women, and children be mentioned specifically in the bill with a view to receiving notice and correspondence? At the moment, the bill doesn't cater for that. The bill has takes a neutral stance in relation to anyone who has interests, rights or interests in the property that's being considered for expropriation and which has been expropriated. In the investigative stage, it might be that special attention needs to be given to the fact that women and households headed by children might not hold property rights, but they are users of property. They are the beneficiaries of property. And if only the holders of property rights, like the husbands or other spouses, are the only ones given notice and consulted, it may exclude people who have interest in the property. And these are particularly vulnerable people who otherwise might not have say because of other power dynamics. Whether they should be included is a question for the committee to decide. But it is an issue that commends itself to further consideration, I think. These are particularly vulnerable members in society. And to that list, I would also add disabled persons, persons who might not be able to receive communication in the standard written way. Whether those people would be, that class of persons would be affected by an intended expropriation is something that the expropriating authority should identify up front and then adopt notice procedures which are appropriate and effective for that class to be adequately consulted. Again, this isn't something that Section 7 mentions expressly, but perhaps the Limpopo Provincial Legislature has focused quite a bit on the interests of traditional leaders and rights in land which are held in a communal fashion. There is an act called the Interim Protection of Informal Land Rights Act, which was passed in 1996 and which was meant to have lapsed a year later. That's why the act was called interim. But the act provides for extension by the minister, and the relevant minister in this case is the Minister of Rural Development and Land Reform. That minister has extended the Act's operation every year since it was made operational in 1996. The Act governs deprivation of communally held property rights in land. The Act expressly subordinates the deprivation of property from persons who hold land in terms of customary title, which the Act defines as informal rights to land. And it subordinates the deprivation to the Expropriation Act and to any law which regulates expropriation. So it's possible for property held in terms of customary title, either by individuals or in a communal fashion, to be expropriated. The Act, that is the Protection of Informal Rights Act, does not set out a procedure for expropriations and consultation for expropriations. It leaves that to the 1975 Act or any other expropriation law. But it does deal with how members of a community are meant to be consulted if they are to be deprived of their property rights in some other way. In other words, other than expropriation. And the way in which the Act regulates that kind of consultation process might be a useful benchmark for the committee to consider if it were to create a special provision dealing with consultation of customary communities which hold land in a communal fashion. The bill currently provides for notice and consultation with individuals. It's possible to interpret the provisions of the Act to deal with communal property rights, but it does not appear to me that the bill accounts for the customary law rules which might govern consultation. So I did a case a few years ago. Actually, I wasn't in the case. I was working for the court at the time, where the rules governing a valid kota kote among people in the Bakhatla group was an issue, and that had to be proved as a matter of fact. Those rules might be different from the rules governing an imbizo in a different community. And so how community members are to be consulted and decisions taken collectively, for instance, if the community wants to agree to a proposed amount of compensation, doesn't appear to be covered by the bill adequately insofar as it doesn't account for the system of customary law which would be relevant to that exercise. It's possible that that could be dealt with in regulations, but if it is to be dealt with in regulations, then guidance should be provided by Parliament in the Act itself to say something to the effect like the minister must make regulations dealing with a notice and consultation process with communities whose rights in land are derived from shared rules, determining access held in common by such group, and link that to systems of customary law. So it's not just any group of persons. It's not a homeowners association or people, as my colleague from the department mentioned earlier on, from a town like Orania or another community that wants to isolate. It would have to be linked particularly to customary law systems. And then the minister will have the the rulemaking power to deal with appropriate consultation procedures which account for the various or relevant systems of customary law to that particular community. This is a very difficult issue, I must say, and I don't think that I think the committee would have to be quite careful in formulating general variables that should guide the minister's power to make regulations, if that's the route it adopts, because no one-size-fits-all procedure will cover the different systems of customary law in the country. Bearing in mind also that the systems of customary law are living, they change. Rather, the rules within those systems are living and change. So it may be that there is a procedural gap in the notice and service procedures under the bill insofar as it concerns communities who hold land under customary title and in a communal fashion. The Northwest Province submitted comments, and I don't want to repeat comments dealing with customary land, but one of the issues raised was whether communities should be able to request land for community purposes. Going back a step, it's important to remember that this bill empowers only one organ of state to expropriate property for a particular purpose, and that's the Minister of Public Works. The Minister of Public Works may expropriate land for public works purposes, and that's for national public works purposes. National public works is an area of, it's not listed as an area of competence in the schedules 4 or 5 to the Constitution. It forms part of the national government's plenary competence. And insofar as the Act relates to other expropriating authorities, it simply lays out a procedural framework for exercising powers which are conferred on other expropriating authorities by their own empowering law. Let me give you an example to illustrate the point. The bill does not empower the Minister of Education or the MECs for Education to expropriate land for education purposes. There is specific education legislation which does that. What the bill would do, if it is passed, is to require the MEC for Education, if that MEC decides to expropriate land in terms of the empowering education legislation, to follow the process under the bill. So, to return to the Northwest's question, may communities request land under the bill for their own purposes? The answer is, it depends. If the community requests land for public works purposes, and it is for national public works purposes, or it's for the use of an organ of state which could request land from the minister for public works related purposes, then yes, they probably could. But if the community requests land for a purpose which goes beyond the scope of public works, then they may need to make that request to the competent authority, the relevant organ of state or member of the executive who administers that particular law. If the communities need a school hall, for instance, they could make the request to the MEC for Education, using the example I gave you. That would be requesting land for a public purpose. But if the community wants land for its own community use or for use by individuals in the community, in other words, they want the land in the public interest, then the public interest would have to be a public interest contemplated in empowering legislation. The bill, depending on the public interest, the bill might not be the appropriate piece of legislation. Let's say the public interest is land reform. Then the community would have to make the request to the competent executive member who administers land reform legislation. And if that member of the executive decides that this is a public interest which fits under the empowering legislation and decides to expropriate the land for that public interest, the process of expropriation would have to follow the bill if it becomes an act. So that's the answer. The Eastern Cape Provincial Legislature has again questioned the meaning of property as it's defined in the bill. I have advised on this before. The bill is designed to track the meaning of property in Section 25 of the Constitution. The meaning of property in Section 25 of the Constitution is constantly developing, and it's developed through the courts. If the bill is not symmetrical with the meaning of property under the Constitution, there is a risk that the procedural protections under the bill will not cover property which is constitutional property under the Constitution, but which is not property recognized under the bill. And the risk of that gap is something the bill should avoid. It avoids that risk by ensuring that the definition of property is always symmetrical, identical with the meaning of property under the Constitution. Of course, there might be instances where property that's recognized under the Constitution simply can't be expropriated. Let me give you an example. Let's say through an administrative process, a decision maker grants a license to a member of the public. That license could be constitutional property according to the Shoprite case, depending on the facts, of course. But if the license were to be revoked or otherwise, or the rights under the license otherwise diminished by the relevant authority, that is not necessarily an expropriation, even though it might be a deprivation. So that kind of property, even though there is a deprivation by an organ of state, a loss by an organ of state, it might not be expropriation. But is there any harm in ensuring that the definition of property tracks the definition of property under the Constitution, where those unusual circumstances arise in the case of that kind of license? No, there isn't. Whereas if property which could be expropriated, property under the Constitution which is capable of expropriation in terms of empowering legislation, is expropriated, but not in terms of the bill because it's not required to comply with the bill, then there's a problem. That's something the bill should avoid. All right. The Free State Legislature also made comments on the definition of property, and I think in large part they are comments which mirror the concerns expressed by the Eastern Cape Legislature. That is, what is the content of property? Should the bill not be more specific? And to that, my answer would be the same. The Northwest Province similarly wanted the term property to be defined with more detail, and the same comments apply. Public purpose. The Free State Provincial Legislature wanted public purpose to be perhaps defined differently. I do agree with the sentiment that the Free State Legislature expresses insofar as the bill does not adequately address transfers directly to third parties in the public interest. This is something that I've provided written advice on, and I'm not going to repeat it here today. The Gauteng Provincial Legislature would like intangible property to be more clearly defined, or for intangible property to be excluded from the purview of the bill. Intangible property derives its meaning from the common law, and it's well established. But going back to the example I referred to earlier, there may be types of constitutional property which are intangible, like the grocer's license, but which is not property under the common law. But whether one needs to stipulate what intangible property is under the bill is doubtful. I think one can leave it up to the common law, precisely because the kinds of property that might be recognized as under the Constitution as intangible property, but not under the common law, might not in any event be capable of expropriation. The Western Cape Provincial Parliament also questioned the definition or the lack of a definition of intangible property. It proposed that there should be guidelines for the expropriation of intangible property. And there may be merit in that, because the bill, although it provides for assessment and valuation of all kinds of property, and for that process, for the valuation process to be conducted by a suitably qualified person, the other provisions of the bill might simply not be applicable to intangible property. I'm not aware of other practical requirements that would be necessary for expropriating intangible property. I can't think of any off the top of my head. But that may be something best dealt with in subordinate legislation. If it is to be dealt with in subordinate legislation, the committee may want to hear further submissions on whether, on the kinds of variables it should set for expropriating intangible property. If there are variables that need to be set, then that should be the way the committee goes. But even if there are, and they have not yet been set, I'm not sure the definition of property should exclude intangible property. The variables can always be prescribed in regulations in due course. And those regulations could be created before the bill is brought into operation so that there's no gap. I note the Western Cape Provincial Parliament's wish that a counter-offer mechanism should be put into the bill. I have given written advice on this before, and again, it's a policy question whether the committee decides to go with the mediation route as a way for an affected person to make a counter-offer, or whether the committee wants to build in another stage into the expropriation negotiation process, at least on the amount of compensation. The Gauteng Provincial Legislature requested that the definition of holder of a right should include a registered right. Currently, the definition of owner under the bill includes holders of registered rights which are required to be registered and which have been registered. So that would cover the Gauteng Provincial Legislature's concern. There was, however, a concern which the Minerals Association raised, or it was either them or Agri SA or AfriForum, about rights that have been conferred under the MPRDA, which require registration, but which have not yet been registered. What happens to those rights? They don't fall under, holders of those rights won't fall under the definition of owner or under the definition of holder. And I do think that gap is something the committee needs to think about. I must say it puzzles me, and I wasn't certain how to fill that gap with some kind of legislative language, but I do think it's something important to consider. And with the assistance of the department, I'm happy to workshop that with them. I'm sorry I can't give a concrete answer right now. This is a repetition of what the Gauteng Provincial Legislature requested. That is that the definition of holder of a right include holder of a registered right. The Gauteng Provincial Legislature asked that the definition of expropriation be amended to include temporary use. And this highlighted, or rather this linked to a problem which I identified during the committee's engagements with the parliamentary legal advisor at the previous session. In my written advice, I noted that Section 7 of the bill, which governs the notice of intention to expropriate, refers in clause 7 to F to temporary use of the property in the future and the intended period of such temporary use. The parliamentary legal advisor's advice to the committee was that temporary use is intended to be permitted only in the case of urgent expropriations, and urgent expropriations would be governed under clause 20. The advice was that temporary use would not be permissible where property is expropriated in the ordinary course, that is, in non-urgent circumstances. But if that was so, then Section 7, which governs notice of intention to expropriate only in non-urgent circumstances, should not refer to temporary use. Its reference to temporary use denotes that temporary use is permissible in non-urgent circumstances. And if that is not the intention, then the committee should give serious consideration to deleting clause 7 to F. I should also mention that clause 23 exempts an expropriating authority from complying with Section 7, precisely because the property will be taken under urgent circumstances in terms of clause 20. So to respond to the Gauteng Provincial Legislature's question, the answer is yes, temporary expropriation is expropriation, but only in urgent circumstances. And I think the answer is to correct clause 7.2f, and also in the application section of the bill, to ensure that clause 2.4 makes it clear that the power to expropriate includes the power to acquire a right to use property temporarily be linked to clause 20. So it should say the power to expropriate includes the power to acquire a right to use property temporarily in terms of section 20, so that a temporary use in non-urgent circumstances is necessarily excluded by implication. If the committee adopts that route, it needn't amend the definition of expropriation. Because even with temporary use, the definition of expropriation holds, because it would be the compulsory acquisition of property, albeit not permanently, for a public purpose or in the public interest. Again, I would remind the committee of my written advice on amending the definition of expropriation to include transfers to third parties in the public interest. So at the moment, the definition of expropriation governs only acquisitions by an expropriating authority or by an organ of state through an expropriating authority, but it doesn't cover transfers to third parties, private third parties, through an expropriating authority's exercise of its expropriatory powers. And that's a huge problem. All right. KZN provincial legislature said that the definition of expropriation was too narrow and adds encumbrances which are not present in the constitutional use of the word expropriation. I'm afraid I don't understand the comment. And perhaps the KZN provincial legislature could elaborate. The Western Cape also recommended an amendment to the definition of expropriation, and its amendment sought to introduce indirect expropriation into the definition. And I would simply refer to what I've said earlier about indirect expropriation. The Gauteng provincial legislature also wanted indirect expropriation to feature in the inclusion of a new definition, which is and the proposal is the compulsory acquisition of property. I refer to what I've said about indirect expropriation earlier on. I should also mention something about custodial takings. Indirect expropriation, as it's understood in other jurisdictions and internationally, is unintentional. There is no intention on the part of the expropriator to acquire rights in the property. Whereas custodial takings entail or signify some kind of guardianship that the state has over property, which falls short of ownership. So I'm not sure that the two are equivalent. And the Gauteng provincial legislature's proposal in a subparagraph 2 suggests that they are equivalent. The Western Cape Provincial Legislature, again in this proposed new definition, wanted temporary expropriation to be clarified. I've made submissions on that. And wanted the curtailment of rights to feature. This suggests that regulation of rights or termination of rights in terms of the state's, I beg your pardon? Chairperson, there was a question, I believe. Chairperson, I believe a member had a question.
I'm trying to check. Is it on the chat?
I'm not sure, but I heard a voice.
No. Continue, advocate.
Thank you, Chairperson. Am I going at an acceptable pace?
Yeah, no. I think you're on track. You're on track. Like as you said, it's important that you take the select committee in confidence. Probably what we could do, maybe in relation to, if there's any question they will raise, they will do that by the raise your hand option indication. So you can continue. Yes.
Chairperson, before I forget, I had picked up a comment from the Gauteng Provincial Legislature in the submissions about, and it's not something addressed in the table, it's something that occurred to me last night when I was preparing.
I don't know whether is it your video. There was movement on your video, but it's okay now. You can proceed.
Thank you, Chairperson. Before I go back to the table, I'd like to point out that the Gauteng, I believe it was the Gauteng Provincial Legislature, which raised a very pertinent question. And it's something not addressed in the table. It's the same issue which the Minerals Council of South Africa raised only in one line in its submission, and that is whether the bill complies with Section 25(2)(b) of the Constitution insofar as the manner and timing of payment are not made subject to agreement or approval or decision by a court. I'd just like to read the text of Section 25(2)(b) out loud. Property may be expropriated only in terms of law of general application, subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. Now, the bill, when it was before the NA, was reformulated to ensure that the amount of compensation was either agreed to or decided or approved by a court before the expropriating authority takes its decision to expropriate. And that's because it tracks the language of Section 25(2)(b), but also because knowing what the amount of compensation has to be will assist the expropriating authority in deciding whether it wants to expropriate at all. Notionally, a court could decide that the amount of compensation offered is insufficient and require that much higher compensation than what the expropriating authority is willing to pay would be just and equitable. The expropriating authority can't be obliged to proceed to expropriate in those circumstances, and the bill recognizes that. The bill gives it a discretion to proceed, and if it does decide to proceed, it must do so it must do so within a reasonable time. The relevant clause is 7.5, which says, the expropriating authority must consider the statements contemplated in subsection 4, as well as any objections or submissions lodged in terms of subsection 2 in deciding whether to proceed with an expropriation of the property. And subsection 6 says, the expropriating authority may decide to expropriate the property after the amount of compensation has been agreed with the owner, mortgagee or holder of a right, or approved or decided by a court subject to section 19.8, which is the dispute resolution provisions. But the point is that when this was debated before the NA, the debate didn't take into account whether the time and manner of payment should also be subject to agreement or decision by a court. What the bill does instead is to have provisions which regulate, as rules of law, how payment is to be made. It prescribes various options and when payment is to be made. But it doesn't leave it up to the agreement of the parties or to a court order. And I wonder whether that could be remediated through an easy and quick amendment. And this is something that I need to give serious consideration to, and I don't have instructions on it. It's something I need to consult the department on. But it may be that this could be solved through an easy amendment. I'm just pointing out now what the legal concern was raised by, I believe it was Gauteng, and also by the Minerals Council of South Africa, which is something you asked me to consider at the last meeting, Chairperson, and to say to the committee that serious consideration needs to be given to this. I'm not sure that it doesn't seem to me that the way in which the bill, and this is just at face value, it doesn't seem to me, subject to further consideration, that the bill limits the right in section 25(2)(b) of the Constitution. It just regulates the way in which the timing and manner of payment is ultimately dealt with in a different way from what section 25(2)(b) of the Constitution contemplates. And I'm not sure if that's enough to prove a limitation of the right, which requires justification, or whether it's a different procedure which isn't a limitation and therefore does not require justification. It's something that I do need to flag with you, Chair, because you asked me to consider it.
We will definitely appreciate that. I guess even the parliamentary legal advisor, together with the department, will ensure that when we meet next week, there's clarity of thought around that. Thank you, Advocate. But we are happy that you, in terms of the elaboration that you are making, but like as you said, that you do not have a mandate on that. But hence I'm saying that yourself, the department, and the state law advisor and the parliamentary legal advisor must be able to help us in terms of ensuring there is clarity of thought around that when we meet next week. Thank you.
Thank you, Chairperson. And I note that you referred to hearings of the committee, sittings of the committee next week. I have raised this with the department. This may not be a relevant consideration for the committee, but I have a court commitment in George next week, and I will be in George from Sunday and returning to chambers in Cape Town on Thursday. I know that council's unavailability is not necessarily something that the committee will be limited by, but it is something that I would like to just raise with you, because I will not be in a position to provide written advice. There this weekend, I'll be fully committed to the court proceedings in George.
All right. No. We take that into consideration. But I think between now, our parliamentary staff will be able to interact closely with the department on that. Thank you.
Thank you, Chairperson. I'll return to the table. The Western Cape Provincial Parliament asked for the Gauteng Provincial Legislature asked for the definition of public purpose to be made clearer. Turning to that definition, it seems to me that it's certainly more detailed than what was there before. And I think it is sufficiently clear. It might be worthwhile just to unpack that for the sake of further discussion. The definition says public purpose includes, so it's not limited to what's stated in the bill, in the definition. It's a non-exhaustive definition, as we call it. So public purpose includes any purposes connected to the administration of any law by an organ of state. So it's defined in terms of a different law from the bill, a different empowering law. And that empowering law must relate to this, in terms of which the property concerned will be used by or for the benefit of the public. So there must be another law, unless the expropriation is by the Minister of Public Works. There must be another law. That law must vest a power of expropriation in a particular organ of state, usually the organ of state which administers that act, or it could be someone like a DG or some other delegated person. The law must have a particular purpose. And in the example I gave you of the education space, it was one of the Education Acts which would empower the MEC to expropriate property. And the purpose would be for education purposes connected with the empowering legislation. And that the purpose must be for use by the public or in the public interest. What does use by the public imply? It implies a very direct relationship between members of the public and the property itself. Members of the public should be able to use that property directly. So in the case of a school or a school ground or a library, which attaches to, say, a university or a school, or even a public library, the members of the public, as members of the public, are able to use that property in a rather direct sense. It could also be that members of the public benefit from that property being used for a public purpose. So in an indirect sense, members of the public benefit. Let me give you an example. Let's say, and let's stick with the Department of Education. Let's say the Department of Education is leasing property for its offices, for its head office or a storage space. And the lease is onerous. It's very expensive to lease property. In the long run, it might be more cost-effective for the department to own property. And if the MEC is unable to purchase property on reasonable terms, the MEC might want to expropriate property for use by the department. That would be covered by the public purpose requirement, or possibly public interest, or both. The point is that if that property is expropriated, it's not necessarily going to be used directly by members of the public. It's going to be used by officials, predominantly of the department. And those officials, in performing their functions, will be doing so for education purposes, for the purpose of the Act. And so it benefits the public in a less direct sense, but it's still for a public purpose. Moving on to the last element, if property is to be expropriated in the public interest, and the clearest example, which comes directly from the Constitution, is land reform, or water reform, or mineral or related reform, then there needs to be a law which deals with that purpose and which empowers an organ of state to expropriate land for that purpose in the public interest. Oh, I'm sorry. Please ignore what I've said about the public interest. That's regulated under a separate definition. That's regulated under the definition of public interest, obviously. Please forgive me. So public purpose is limited to expropriation of property which is going to be used by the public. Whether that's in a direct or indirect sense is a question of interpretation, but that's really where it fits under. It fits under public purpose, not public interest. So when one looks at it that way, when one breaks the definition down into its constitutive parts, I would submit that it's reasonably clear what it means, that it isn't vague, as Gauteng says, and that it meets the requirement of reasonable clarity, which is part of the rule of law. Moving on to the definition of valuer. As far as the bill relates to immovable property, a valuer means a valuer appointed as such under the Property Valuers Professions Act. But where the bill relates to property other than immovable property, then a valuer needs to be someone who is appropriately, the bill says, suitably qualified to value that property, that particular property, which is not immovable property. So if government, if an organ of state needs to expropriate buses for a pressing public purpose, then someone who can value those buses needs to be able to assist the expropriating authority to determine an appropriate amount of compensation. It wouldn't be appropriate for someone qualified under the Property Valuers Professions Act who's qualified only to value immovable property to do so. So who values the property has to fit the nature of the property. And that's what the bill seeks to do by having this more expansive definition of the term valuer. So I hope that addresses the concerns that both Gauteng and the provincial legislature of the Western Cape have raised. The Free State Provincial Legislature questioned the application of the Act, and I think they referred to Clause 2.1, which says, despite provisions of any other law, an expropriating authority may not expropriate property or cause it to be acquired under subsection 3 arbitrarily or for public purpose other than a public purpose or in the public interest. And the Free State says it questions why the formulation of this provision is in the negative. It says what they may not do rather than what they may do. It's not couched in the language of empowerment. It's couched in the language of restraint and restriction. And that's not generally how one drafts law, unless the restraint is a qualification on a power or an outright prohibition of some kind. This is really a matter of what the committee thinks is appropriate. The legal result is 6 of one and half a dozen of the other. They mean the same thing ultimately. But there is something to be said for the fact that this law is not couched in empowering terms. It's not couched positively, it's couched negatively. And as a rhetorical tool, because that's how Parliament speaks through its legislation, as a rhetorical tool, I think it would have better impact if the Free State's proposal were adopted, if the bill were to say instead, an expropriating authority may expropriate property only in terms of this act, or something to that effect. Moving on, Clause 2.2 deals with the requirement to exhaust private means of acquiring the property. So it says, subject to Section 20, which is about urgent expropriations, a power to expropriate property may not be exercised unless the expropriating authority has without success attempted to reach an agreement with the owner or holder of a right for the acquisition thereof on reasonable terms. So here, subsection 2 is the restraint that I referred to earlier, but it should be a restraint on a power, on an empowerment, rather than a restraint on yet another restraint, on a more general restraint. And so that really speaks to the Free State's proposal about Clause 2.1. But focusing on Clause 2.2, the KZN Provincial Legislature has proposed that reasonable terms be defined. And the reason it should be defined is to avoid essentially what are not bona fide attempts at negotiation for purchase. If I rewind, so I'm a child of the 80s. If I go back, it's important to highlight the words in Clause 2.2. Attempted to reach agreement with the owner or holder of a right. And the agreement must relate to acquisition of the property. So it's a transfer of ownership, not an expropriation. It's a transfer of ownership by agreement. And so there would be the formation of a contract which creates binding rights and duties on each of the parties. The contract must be formulated on reasonable terms. So according to our law, reasonable terms in general would not be unfair, and of course definitionally would not be unreasonable. They would certainly not be irrational. The Constitutional Court has made it clear that the terms of a contract and the enforcement of a contract, particularly where there is a disparity in bargaining power, should not be unfair or unreasonable to the party which is in an inferior bargaining position. And the court may decline to enforce that kind of contract if it is to the detriment of the less powerful party. So what would reasonable terms be? Lawful terms would be anything that the parties agreed on which is permitted and not prohibited by law. In negotiating reasonable terms, I would agree that the expropriating authority shouldn't do it in a half-hearted attempt simply to tick the box so that it can actually expropriate. It shouldn't, for instance, put in an offer that's so low that no reasonable owner would accept it, knowing that in due course it could expropriate the property perhaps for slightly more because it would be just and equitable, but for less than what knowing that it would necessarily be less than what the owner would accept, because what Section 2.2 seeks to achieve is consensus on what the market value of the property would be. It's not about what's just and equitable. It's about what the parties. It's about achieving what the parties would agree on in an open market where there's a willing buyer and willing seller. So I do think that reasonable terms mean terms that are arrived at through good faith negotiations. But I'm not certain that reasonable terms needs to be defined. Reasonable terms should be left up to the parties. It's really, reasonable terms are the product of good faith negotiations. And the emphasis should be on the negotiations being in good faith rather than on the outcome of the good faith negotiations. In other words, on what the terms the parties have agreed on are. So I don't agree that reasonable terms should be defined. What should be emphasized is that the negotiations be conducted in good faith. And if the committee wants to add in that as a requirement, the appropriate point to do it would be in clause 2.2, not in the definition section. As a matter of good drafting, definition sections do not impose substantive duties or establish substantive rights. That is the function of the main body of an Act of Parliament. Clause 2.3. The Eastern Cape Provincial Legislature has asked that Clause 2.3 be amended. And it wants it to be amended to refer to custodianship of land and control of land under traditional leader or chief. And the expropriating authority must follow the customary practices and processes in expropriating such land. I think it raises an issue which I've alluded to earlier on about the necessity about the importance of acknowledging at least the procedural aspects of customary law in exercising the power of expropriation. But I'm not certain that a general rule like this would fit with all systems of customary law, because it isn't clear that all systems of customary law vest ownership, control, or custodianship in a traditional leader or chief. Yes. Whether the bill should distinguish clearly between land in urban areas and communal land in rural areas might be dealt with without having to make an express distinction. It might be dealt with by including a provision which deals with service and consultation with communities that hold land communally in terms of a customary law system. And by implication, it would mean that everyone else who isn't subject to that kind of customary law system is dealt with under the other provisions of the bill. Clause 3, which deals with the powers of the Minister of Public Works, or rather, more correctly, the minister responsible for public works and infrastructure. There seems to be a misconception, as I mentioned earlier, that the bill empowers the minister to become a kind of super expropriating authority, that anyone, even organs of state with their own powers of expropriation, must go through the Minister of Public Works to expropriate property. And that's not correct. The Minister of Public Works has circumscribed powers of expropriation, and the circumscription is in clause 3, 2, and 3. Clause 3.3 says that the minister's power to expropriate property in terms of subsections 1 and 2 includes the power to expropriate property to be used for the provision and management of the accommodation and land and infrastructure needs of an organ of state. Those really are the core functions of public works and infrastructure. The minister, for instance, wouldn't be expropriating land for the school hockey field if that is a power that the MEC for Education has. So perhaps the concern that the Provincial Free State Legislature raises about the definition of property being broad, and the Minister of Public Works' power to expropriate property rests on this incorrect assumption that the Minister of Public Works has the power to expropriate all property. And so if one disposes of the incorrect assumption, then the concern falls away. The KZN Provincial Legislature suggests that Clause 3.1 be amended to provide, subject to the provisions of Chapter 5, the minister may expropriate property for the public purpose or in the public interest, with the exception of land expropriated for land reform. Again, this seems to rely on the incorrect assumption I referred to just now. Land reform is regulated under land reform legislation. There is a different minister who is responsible for the administration of land reform legislation. That land reform legislation vests that minister with powers of expropriation for land reform purposes. The Minister of Public Works' powers to expropriate land are limited to public works purposes and include those functions mentioned in Clause 3.3. Those functions don't include land reform. And so I don't think that concern really arises on a proper interpretation of the bill. Chairperson, may I, subject to your direction, request a short break?
Yes, I think it's only correct that you are able to take a breath, advocate. I do. 5 minutes break, that's fine.
Thank you very much.
Thank you.
How long, Chairperson?
5 minutes break will do.
5 minutes. Thank you, Chairperson.
Thank you. Advocate?
Yes, Mr.
You want
Chairperson.
to propose that you push until 11:30, so that we are then able to give the parliamentary legal advisor and also the state law advisor to come in. Thank you, Advocate. Thanks.
Chairperson, the remaining responses are in writing if the committee wishes to refer to them. There is a matter which occurred to me during the break, and it's relevant to the issue of customary land held communally. First, I think this is a very important issue, and it's one that needs to be dealt with respect and sensitivity. Secondly, I think that the way in which the committee can approach the challenge of consulting with communities as opposed to individuals need not require reinvention of the wheel. There is an act of parliament which I referred to before, and I'm proposing to put it on screen now. It's called the Interim Protection of Informal Land Rights Act, and it's Act 31 of 1996. I'm going to put it up on screen to show the committee that there may be helpful language in another act of parliament on which it can rely. Mr. Chairperson, can you see the name of the act on screen?
Yes. No, yeah, we can see. I also saw it. I think in one of your notes it was also appearing when I went through it yesterday.
Thank you. So I just want to draw the committee's attention to some important clauses which might be helpful in formulating language. This act broadly deals with how persons holding land predominantly under traditional law, customary law, can lose their rights to land. That could either be through voluntary disposal or some other deprivation. And this land does provide that one of the means of deprivation is through expropriation under the current 1975 Act. What is important for the purposes of giving notice under this Act, or relevant perhaps, is the language of section 2.4. It says, for the purposes of this section, the custom and usage of a community shall be deemed to include the principle that a decision to dispose of any such right, that is the communal right to own land, may only be taken by a majority of the holders of such rights, present or represented at a meeting convened for the purpose of considering such disposal, and of which they have been given sufficient notice, and in which they have had a reasonable opportunity to participate. What this section does is it respects the fact that different communities might have different systems of law with different rules regarding consultation and decision-making. But it says, whatever your rules may be, an act of parliament is going to deem it through a legal fiction that one of the rules is this rule about consultation. Even if it's not part of your custom, the law is imposing it on you. You must take a decision by a majority of everyone who is entitled to be at that meeting. So depending on the custom, it may only be heads of households. It might only be males. It might only be females. It might only be people who are on a council or elders, whatever the case may be. But this deeming provision, I think, is something that the committee should consider for transposing, if it's appropriate, into the bill when it comes to consulting with holders of communal land. The second point I'd like to make with reference to this act is that it empowers the minister responsible for rural development and land reform to make regulations. And although I haven't found any regulations promulgated under this act concerning the manner of consultation, it may be that homework was done in that department already. They might already have researched the point and produced some kind of policy document on consultation, which this committee might benefit from. So, Chairperson, of course, through you, the committee might decide to invite that department, rural development, to make available any such policy documents for the purpose of crafting an appropriate provision in the bill. Thank you, Chairperson. I'm going to return the screen to the table.
The
Western Cape commented that Clause 3.3, both Gauteng and the Western Cape provincial legislatures commented that Clause 3.3 is superfluous. And Clause 3.3 is the one I read out concerning the Minister of Public Works powers. I think the reason they believe it's superfluous is because they think the Minister of Public Works is a super expropriator. He can expropriate any property, provided it's in the public interest or for public purpose. That's not the case, and I've explained why. Gauteng Provincial Legislature wants Clause 3.5a to be amended. Clause 3.5a provides that when the minister expropriates property on behalf of an organ of state that does not itself have powers of expropriation, ownership of the property vests in the relevant organ of state on the date of expropriation. Gauteng would like that to be amended to say ownership vests on the date on which transfer of ownership of the property is registered by the relevant deeds registry office in terms of the Deeds Registries Act. And the word of expropriation should be deleted. Some basic principles of property law. First, there are different ways in which property can be acquired. One of the ways property can be acquired is by agreement. If person A agrees with person B, that person A will give the property and person B will give the property, that's called transfer. Transfer is subject to a condition in the Deeds Registries Act. The condition is that transfer will be effective only once it is registered. So registration is a condition on transfer. Expropriation is different. It does not require agreement of person A and person B. It's what's called a mode of original acquisition of property. Consensus is irrelevant. And if there's no consensus, there's no transfer. And if there's no transfer, there's no condition in the Deeds Registries Act that transfer must be registered. It simply does not arise as a requirement. Expropriation is the act of acquiring ownership. So when the notice of expropriation is served, that's it. Ownership passes. So I disagree with the proposal as a matter of law. Similarly, the Western Cape made a proposal that I beg your pardon. In addition to this proposal, Gauteng asked that the payment of compensation be a prerequisite of vesting. And this is a proposal that the Western Cape Provincial Parliament echoes. The Constitutional Court has said that the determination of compensation should in general precede expropriation. But in exceptional cases, it may be that it is just and equitable to determine compensation after expropriation. That's the case of Hafiji. Now, the bill, when it was crafted, took heed of Hafiji. The Section 20, rather Clause 20, which deals with urgent expropriations, allows for payment of compensation after, rather determination of compensation after expropriation. Whereas in non-urgent circumstances, determination of compensation must happen before a decision to expropriate is taken. And I've referred the committee already to Clause 7(6)(a) of the bill. Determination of compensation logically must precede payment of compensation. The bill does not provide for payment to precede vesting. The bill provides, in the ordinary course of expropriation, the bill provides for payment to precede the date on which the right to possession of the property passes to the expropriating authority. Let me explain. The Act provides that ownership will vest in the expropriating authority on the date of expropriation. But the expropriating authority, despite being the owner, does not have the power to take possession, the right to take possession of that property immediately. The right to take possession of the property can only happen on a date after it gets ownership. And that's to give the expropriated owner a window period in which to adjust their affairs. It would be unjust, unreasonable to expect someone who has just been expropriated to vacate their home on the same day. A transitional period is built in, therefore, into the notice of expropriation. And payment of compensation must be made not before the date of expropriation, but before the date on which the right to acquire possession vests in the expropriating authority. And only once that right vests can the expropriating authority physically take the property. The window period in the interim, when the expropriated owner is reordering their affairs, it might well be that the expropriated owner will not have the means to reorder their affairs unless and until compensation is paid. It stands to reason that that may be the case in many, that may be so in many cases. And so how far the date of payment is from the date on which possession takes place is perhaps something for regulations to consider in order to give someone, an expropriated person, enough time and means to make alternative arrangements. I should also say, and I should probably have mentioned this earlier on, one can't pay compensation before taking a decision to expropriate, because the decision to expropriate, it's only on the assumption that there will be an expropriation that compensation can be paid. So I don't think that the proposal by Gauteng and the Western Cape is possible You can't pay compensation unless you know you're going to take the property. So the payment of compensation can only come after a decision to expropriate has been taken. And the real question is where, in between the date of expropriation and the date on which the right to take possession of the property, payment of compensation occurs. I think that's the real issue. And Mr. Chairman, Mr. Chairperson, I'm afraid I don't have the answer. That really is a policy question for the committee to decide. It's not for a lawyer. It may be that certain variables could be built in, like the practicalities of finding alternative accommodation if property is a home or residence, the practicalities of relocating and starting up another business, or getting into production on another farm, or acquiring a different car. The time periods may vary depending on the circumstances. And if the committee is going to prescribe anything, it should be very mindful that the circumstances are elastic, they're variable. The Gauteng Provincial Legislature suggests that Clause 35B be amended so that the right to acquire possession of the property should vest on transfer of ownership to the relevant organ of state and not before. Well, as I've mentioned, the right to possession cannot occur before ownership vests. And this is referred to in two places in the bill. Clause 7.2G, which is in the notice of intention to expropriate, requires the expropriating authority to stipulate the date on which it intends to take possession of the property. And that date must be after in the date of expropriation, the future date, it says. And clause 8.3e, which is the clause governing the notice of expropriation, requires the notice of expropriation to stipulate the future date of expropriation. Oh, I beg your pardon. It's F, paragraph F, the future date on which the right to possession of the property will pass to the expropriating authority after expropriation. Chairperson, I've just realized, and I think I pointed this out in my note, there's an error in clause 8.3e. It should not refer to the future date of expropriation, because the date on which the notice of expropriation is served is the effective date of expropriation. So that doesn't make sense. But of course, it should retain the requirement that the period, oh, I beg your pardon. Yes, in the case of urgent expropriations, it should retain the requirement that the period of temporary use be stipulated in the notice of expropriation under clause 8. And again, the Gauteng Provincial Legislature makes the error of assuming that registration of transfer vests ownership in the organ of state. It does not. The act of expropriation does. The KZN Provincial Legislature proposes that clause 5.7 of the bill be amended. Clause 5.7 deals with the investigation stage. It reads, if the property in question is damaged through an act contemplated in subsection 2. Subsection 2 is the investigation of the property. An affected person may deliver written demand to the expropriating authority, and the expropriating authority must repair the damage to a reasonable standard or compensate for the damage without undue delay. The KZN Provincial Legislature proposes that reasonable standard be changed to refer to the original standard which is acceptable to the property owner. Now, there are 2 points which arise. I've referred only to one. The first is that the original standard might not have been a reasonable standard, might have been less or more. And if it is more, the expropriating authority shouldn't be obliged to compensate for luxuries necessarily, although it may do so. And the expropriating authority shouldn't give a windfall to the person whose property is being inspected by upgrading the property. And secondly, yes, and so what this clause, what these words introduce, which is acceptable to the property owner, is a subjective standard, whereas what should really be the measure is a reasonable standard, an objective standard. So I wouldn't support the proposed formulation. Clause 5.1, sticking with the investigation phase, says that the expropriating authority must consider all relevant factors when deciding whether to expropriate property. And in particular, it must ascertain certain things. Now, Gauteng Provincial Legislature proposes that subjective factors should be included in the list of mandatory considerations, like whether the property has sentimental value. And this echoes the sentiments that the Social Justice Centre that they expressed to the committee when they made their public submissions. It was Professor Madonsela who made those points, and I think they're good points. They're good points because there may be other factors like the loss of a home, the disruption to the social fabric of a community, the sentimental value that attaches to particular property, which is legally relevant, which should be legally relevant, which should play a role, which shouldn't be ignored. And while those factors would be relevant considerations and fall under the general provision under Clause 5.1, it may be that Parliament wants to make it clear to the expropriating authority that they shouldn't be ignored and that special significance should be given to them by listing them in the paragraphs that follow Clause 5.1. That is a policy decision for the committee to make, but it is one that has particular social gravity. And I think Professor Madonsela articulated them very eloquently. It could also be included, which is some of the factors that she mentioned, whether the property is property that's instrumental for business, whether the property is the primary residence or the sole residence of occupiers, whether the property is the only means of generating income. Think, for instance, of a taxi driver who actually owns his own taxi, and that taxi driver's property, the taxi is needed for public purpose or in the public interest. It could be that in an emergency, public transport isn't enough to transport people, and private taxis need to be sequestered. It would be necessary to consider whether, I think it would be relevant to consider at the very least, whether that property, whether the taxi is the only way in which the owner can generate income, and whether depriving the owner of that property would also impact on their ability to earn a living. That might be something that the committee may feel the bill needs to stipulate in express terms, rather than to leave it to the general discretion of an expropriating authority under clause 5.1. And I beg your pardon, also perhaps to consider the submission of the organization which represented religious interests for South Africa, perhaps to consider whether the property is used for religious purposes, or I would even suggest cultural purposes, not just religious purposes, but cultural purposes more significantly. The property could be, well, I mean, of course, there are many examples. It could be of significance to different cultural groups, not necessarily religious groups. The Western Cape Provincial Parliament echoes the Gauteng Provincial Legislature's proposal that subjective factors should also play a role and should feature expressly in clause 5.1 as mandatory considerations, not just permissive considerations. And I should probably also say that they're introducing subjective factors into clause 5.1 might come into tension with clause 12.2a, which says that when computing the amount of just and equitable compensation, one may not take into account the fact that property has been taken without the consent of the expropriated owner or expropriated holder. But of course, if a sentimental consideration is that someone will lose something of sentimental value, then that would potentially clash with the injunction not to consider the fact that property was taken through expropriation and against the will of the owner or holder. I would simply flag that as a consideration. And I would also flag the fact that if property is taken without consent by expropriation, and it is not to be considered, that fact is not to be considered in determining what just and equitable compensation would be, then it would exclude, perhaps unfairly, the payment of salatium. And that's a Latin word which really means compensation for the inconvenience of having lost property in that fashion. Or for injured feelings. And there is no provision, unlike under the 1975 Act, there is no provision in the bill for salatium. Yes, so clause 12.12a suggests that salatium should not be considered in the determination of just and equitable compensation. That may be something the committee wants to revisit. Clause 5.5. Chairperson, I'm mindful of the time, and I don't want to eat into my colleagues' time for presenting. These issues here in these sections are policy matters. I have already covered the comment on clause 5.7 above. It relates to the objective reasonable standard for making good damage to property, as opposed to a subjective standard of what the owner thinks would be adequate compensation or adequate repair. There was a good point that the Gauteng provincial legislature made, I think, in relation to the consultation with municipality point. If land is going to be expropriated, the expropriating authority needs to satisfy itself in terms of clause 5.1 that the land is suitable for the required purpose. To ascertain that, as it must, it needs to know what the features of the land are, how the land has been zoned, whether the land has been earmarked for some kind of future project, what the forward planning instruments are. And this is information that the municipality can and should give to the expropriating authority, where the expropriating authority is not itself the municipality. And the bill requires the municipality to furnish that information in terms of clause 6.3. What the bill does not do is provide for consequence if the municipal manager does not provide the information or does not provide the information within a reasonable time. And it really amounts to a requirement without any kind of stick to enforce it. And of course, the expropriating authority needs this information. It's critical to its assessment. So it can't well say to the municipality, like it can in the case of not furnishing information about outstanding rates, that we're not going to consider your views, they're no longer relevant. The information about the nature of the property, which the municipality has control over, would be critical to the decision to expropriate. So I'm not entirely sure what the appropriate stick should be. But when dealing with municipalities that lack adequate skills or capacity, or which are just defunct, it probably would be wise in including some kind of measure to compel compliance with the request to provide an expropriating authority with information about land. So I do think that the Gauteng Provincial Legislature's recommendation commends itself. The Western Cape Provincial Parliament echoed that proposal. Clause 6.4 is something that also deals with municipalities. The Eastern Cape Provincial Legislature asks that the municipal manager to whom a request for information about land is directed should place that request before the council for deliberation and approval. I'm not sure that's necessary. The request for information is just that. It doesn't require the municipal manager to take any decision or exercise any discretion. It's certainly not a provision that confers any decision-making power in the municipal manager, which might have implications for the municipality or the council, or budgetary, it may have budgetary consequences. No, it is simply a clerical function that the municipal manager will perform. He just needs to collate and pass on the relevant information. So I don't think it's necessary or appropriate to involve the council. it's not a legislative or an executive matter. It's purely clerical. Clause 7.1, which is the notice of intention to expropriate section, the Eastern Cape Provincial Legislature requires the notice of intention to expropriate to be served on the traditional leader concerned. I think that the bill does provide for that, insofar as the expropriating authority must serve notice of intention to expropriate on the holder of a right, and if the traditional leader is acting on behalf or appointed by a community that owns land communally, then he would actually be the agent of the owner. But I would go further and say that it shouldn't just be the traditional leader who gets notice, but it should be everyone who's part of that community if the land is owned communally. And that's something that this committee could expand on in the notice and service section that we debated earlier, or discussed earlier, I should say. Clause 2.2, the Western Cape Provincial Parliament suggests that the notice of intention to expropriate should be amended because it is unclear whether the objections of any person who may be affected by an intended expropriation will be given any weight, and that they will be considered. Well, I'm afraid that they are wrong, because Clause 7.5 expressly requires the expropriating authority to take its decision on the amount of compensation, to consider the statements of persons who make representations in response to a notice of intention to expropriate. So 7.5 is a complete answer. I'm not going to deal with Gauteng. I've dealt with that point earlier on. Clause 7.3. Gauteng is concerned that Clause 7.3, and this is where I will stop, Chairperson, in view of the time. Gauteng is concerned that Clause 7.3, which provides for delivery of the notice to directors general and municipal managers, a municipal manager, of a notice of intention to expropriate, they are concerned, I beg your pardon there, they are concerned that this might not be necessary where property is not land. But this is an unfounded concern because the requirement is subject to a condition, and the condition is if the property is land. If the property is not land, of course, then there will be no need to deliver the notice of intention to expropriate on directors general or the municipal manager. I do have time for one more. I've referred to communal land. I've referred to.
Yeah, you can continue that up to 12 so that we do not gloss over any other thing, but at least let's ensure that sufficient we are able to cover those responses. Advocate Naidu.
Thank you, Chairperson. The Gauteng Provincial Legislature again raises the question of vesting and payment of compensation. Vesting, just to recap, vesting happens on the date of expropriation. Payment happens after the date of expropriation. Payment cannot happen before the date of expropriation because the decision to expropriate hasn't been taken at that juncture. That's really the answer. The Western Cape raised the same concern. The KZN legislature raises an interesting point. Clause 9.3b provides that it deals with the running of it deals with the loss of value, or it should deal with the loss of value of property in between the date of expropriation and the date on which the right to take possession of the land vests in the expropriating authority. Clause 9.3a says that the expropriated owner or expropriated holder who is in possession of the property concerned must take all reasonable steps to maintain the property from the date of expropriation to the date referred to in subsection 2 or 4. And subsection 2 is the date of possession which might be earlier than the stipulated date by agreement. And subsection 4 is the date of expropriation. So the obligation is, even though you as the expropriated person no longer own the property, you have use of it, you've got possession of it, you've got the right to the fruits of the property, but you need to take care of it. You're not required to take care of it beyond what's reasonably necessary, and the law requires that of you. The consequence, and of course, the expropriating authority will compensate you after the date of expropriation for costs necessarily incurred for maintaining the property. That's the import of clause 3AC. So it's not imposing an undue financial burden on the expropriated person, but it's saying because you're in control of the property, take care of it. You are almost the owner, except in name. And that's fair. It seems fair. I'm not sure why I referred to expropriation here. That was my error. Please ignore that. Please forgive me. I was talking all this time about 9.3a and c. I should have been discussing 9.3b. Sorry. 9.3b says the expropriating authority may recover any amount of depreciation caused by the willful or negligent failure of an expropriated owner or the expropriated holder to maintain the property. I think that the KZN provincial legislature is right to identify this particular clause as problematic, but I'm not sure that their proposal is worthy of merit, has merit. The proposal is to change intentional or negligent failure, willful or negligent failure, simply to willful failure. So to exclude negligence. The basis of negligence is objectivity. It's about what a reasonable person would consider reasonable in the particular circumstances and whether a reasonable person would have done something about it. The reasonableness of the steps that an owner can be expected to take to maintain the property ties in very neatly with the notion that the expropriating authority will compensate that owner for reasonable maintenance. Unreasonable maintenance, whether it goes too far or fails to maintain, of course, wouldn't be compensable, but should be penalized, because ultimately it will harm the public interest. The second point is not something that the KZN provincial legislature raised, but it is relevant to its concern. It concerns the amount of depreciation caused. Depreciation is different from value. Value is the actual loss. So if you had a house, for instance, and the house there was an earthquake and a wall fell down, and that wall needs to be repaired because it's important for the structural integrity of the property, or whatever the case may be. It's reasonable to expect the expropriated owner to repair that wall, and the expropriating authority will compensate the owner for the costs, the necessary costs of repair. That's actual loss. It's measured based on real facts. Depreciation is different. It's an accounting fiction which allows someone to record the book value of property over time, over a defined period. It doesn't necessarily turn on the actual state of affairs. So value might be greater than or less than depreciation at any point in time. And secondly, depreciation isn't caused by conduct of an expropriated owner or holder. Depreciation is something that's budgeted into the useful life of the property as an accounting concept over time as a matter of course, not because of any act or omission. So the notion of depreciation, as far as it appears in 9.3b, is wrong and should be replaced with the word value. And the exclusion of negligence as proposed doesn't really fit with the scheme of clause 9.3 overall. Clause 12, I've responded to that in the written advice on nil compensation. I don't propose to repeat that, but to highlight some features, I'm not persuaded that nil compensation can never be just and equitable. There will be examples where it would be just and equitable, potentially. Let's take the example I referred to earlier. Let's say that the expropriating authority took land from A, let's say it's agricultural land, and transferred the land to B in the public interest. Instead of using the land for agriculture, as the intention was underlying the expropriation, person B abuses the land by mining it illegally for sand and strips the land of valuable minerals and nutrients which make it arable and which are essential for its agricultural nature. The expropriating authority might be justified in saying, this land is not serving the intended public purpose. It is against the public interest for this land not to be used for agriculture. I, as the expropriating authority, am therefore going to expropriate that property from B and transfer it to C, or even back to A, whatever the case may be, so that it is used for the intended public purpose. And I may even, and in doing so, I might have to incur additional costs to restore the land or that portion of the land which was unlawfully mined and stripped of essential nutrients and minerals. So the expropriating authority is not only going to have to take the land away, but it's going to have to spend money on rehabilitating the land to get it into a fit condition to be used for agriculture by sea. In those circumstances, it may be eminently just and equitable to say that the expropriating authority should pay nothing to person B. So to say as a matter of principle that nil compensation could never be just and equitable in terms of Section 25(2)(b) of the Constitution, I think is wrong. And I think the counterexample I've just given disproves that. But of course, to say that, and herein I think is the real concern. Just because it's permissible under Section 25(2)(b) and articulated expressly in Clause 12(3) of the bill, does not mean that the bill is licensing the award of nil compensation more than in instances that Section 25(2)(b) would countenance. That would be a mistake. That would be incorrect reason. Because if Clause 12(3) were to allow for the payment or to license nil compensation in circumstances where Section 25(2)(b) of the Constitution would not, then there would be a disjuncture between Clause 25(2)(b) and the bill, and then that limitation of Section 20, it would be a limitation of Section 25(2)(b), and that limitation would have to be a justifiable limitation it would have to be non-arbitrary under Section 25(1) because it permits of a deprivation, and it would also potentially need to meet the test for justifiability under Section 36 of the Constitution. And it's questionable whether that will pass muster. So the correct way to approach Clause 12(3) is to interpret it in a way that coheres with the values of the Constitution, the values of the Bill of Rights, and with the property clause, the import of the property clause, and the principle that compensation should be just and equitable. That principle is in 25(2)(b). So if you approach Clause 12(3) from that perspective, there would always be Clause 12(3) will always match what the Constitution requires. And I believe that an interpretation in that fashion would be consistent with the language of 12(3). And that really should be, that submission should really be dispositive of all the concerns that arise in relation to 12(3) generally. The Western Cape Provincial Parliament has raised a concern about whether the interests of mortgagees are taken into account when compensation is determined. I have done a written note on this, and it is a very pressing concern that the committee must address. I do not believe that it does adequately deal with the interests of mortgagees because Clause 12(1) says that the equitable balance needs to be struck between, on the one hand, the public interest, and on the other hand, the interests of the expropriated owner or expropriated holder. Nobody else, just the expropriated owner and the expropriated holder. That is under-inclusive because mortgagees, as I've argued, are neither owners as defined or holders, yet they have an interest in the property. There may be other people who have an interest in the property, but who do not have who do not have registered rights, or who are not holders of unregistered rights as contemplated in the bill. The cure.
Advocate, where is this written advice?
I provided it to the committee through the department on the previous occasion, Chairperson.
Okay.
It does stipulate.
I'll check with the committee secretary then. No problem.
It does stipulate what the fix is. The fix is to include the words which come directly from the Constitution. And any interested person or any person with an interest in the property. Include those words into clause 12(1) of the bill.
Okay. I will advise, we'll get it and then we'll request it to be circulated amongst members. Thank you.
Thank you, Chairperson. If that is done, Chairperson, then the interests of mortgagees would have to be taken into account when determining the amount of just and equitable compensation and the outstanding amount of any mortgage bond. That's not to say, however, that a mortgage bond will always be paid. Chairperson, there is a question from Honorable Dangor.
Yes, Chairperson, if I may, Chairperson, if the advocate can address the issue, if a property then moves into negative equity because of the threat of compensation, what would the rights of the person who actually provided the loan or the mortgagee, as they would say, what would their rights be in that particular situation? And who would be responsible for the compensation for negative equity?
Thank you, Ambassador. Advocate.
Thank you, Chairperson. In fact, this was the very point I was going to move on to, so it's timing. It's well timed. Let's think away expropriation for a moment. If someone takes a loan from a bank and the loan is secured by way of a mortgage, and the bank wants to, and there's default of the loan, and the bank wants to foreclose on that property, whatever amount the bank gets from foreclosure will be used to satisfy the outstanding indebtedness. That amount is usually the amount that's realized on auction. And it's quite often less than market value. So banks build in a risk factor that they will not necessarily get back the total amount of the outstanding indebtedness if they have to foreclose. That's in the ordinary course. And the law says that any difference which is not satisfied through foreclosing on the mortgaged property must still be paid by the debtor. That's the law. The same principle applies, or should apply, I think, when property is being considered for expropriation and when an expropriating authority, and even a court later, when they are considering the amount of just and equitable compensation, they will ask, perhaps, has this property been, would this property have fetched the amount of money if it was sold on the open market equivalent to the amount of the indebtedness? So if the property hadn't been expropriated, it wasn't going to be expropriated, and the owner said, I want to sell this, will I at least be able to satisfy the bond? Then that will be a factor that the expropriating authority should consider. And ultimately, the question will be, one of the questions will be, is it just and equitable to offer less because it would expose the owner to further liability? That's one possibility. There's another possibility which you postulate. What if the owner had put the property on the market and couldn't fetch a purchase price that would be sufficient to discharge its indebtedness to the bank? Would it be just and equitable to compensate them for less than the outstanding indebtedness? Well, possibly yes, because if the property was over mortgaged, if the bank extended credit over and above what it had securitized its loan for, that risk is a risk the bank bore. That risk and the financial consequences of it need not be borne by the public. Because if a rule is created that the expropriating authority must always pay the outstanding amount of the indebtedness, there is a risk that property may willingly or unwittingly the owner may become over indebted. And who will pay for that? The public. So a fixed rule like that should be avoided. Every expropriation should be assessed on its facts, and the facts will vary from case to case. Another point that you raise, which is particularly important, I think, is what if the property started off in negative equity before it was considered for expropriation? What then? Well, the other point you made, which ties into that, is what was the cause of the property falling into negative equity? And that reminds me of a case called Modiclip. It was an SCA decision which went to the Constitutional Court under the name of in the SCA it was called Modderfontein, and in the Constitutional Court it was called Modiclip. Harms DP wrote the judgment in the SCA, and Langa wrote the judgment in the Constitutional Court. And there the facts were these. A property owner had unlawful occupiers on their property. The property owner took all the lawful steps to evict those occupiers, unlawful occupiers. The property owner went to court. The property owner joined the municipality because the unlawful occupiers faced a risk of homelessness if they were evicted. The property owner ultimately got an eviction order because I think the municipality was obliged to ensure that the evicted persons would not be rendered homeless. The problem was that the property owner couldn't enforce the eviction order because the municipality was not cooperating. The property owner then approached the province, I think, to enforce the order, to provide alternative accommodation. But nothing happened. And I think the property owner tried to instruct the sheriff but the sheriff couldn't do anything because there was nowhere to house the people who would otherwise be rendered homeless. And this placed the property owner in an impossible position. I think the sheriff might even have failed to execute the order. I stand corrected. But the point is, the property owner did everything they could to follow the process lawfully and to respect the rights of the occupiers. The failure lay with the state. It was the state that didn't come to the party, which failed to abide by court orders, which imposed an obligation on it. And one can conceive of situations where the property value goes into negative territory through conduct of the state because of a failure to act. And using the Modderklip example, it could be a failure to provide alternative accommodation. Eventually, the market for that property will disappear. No one will want it. It'll be valued at nil. Notionally, there'll be no market for the property. And not only that, to get the property into a marketable state, extensive relocations would have to be done at private expense. So we could say the market is in that negative zone as you postulated. Should an expropriating authority be obliged to cover the outstanding indebtedness if the property is mortgaged in those circumstances? I think the question a court will ask is, what was the cause of the property falling into negative territory, and would it be just and equitable if the state caused the dip in value to make the private owner bear the loss, essentially bear the loss by remaining indebted to the bank? I think a judge will be hard pressed to think that the fact that the mortgagor will still be lumped with the negative, with the indebtedness, is an irrelevant consideration. I hope that answers your question.
It's fine, Advocate. I suspect the ambassador is okay.
Thank you, Chairperson.
Okay.
I've run out of time. Chairperson, I'm afraid I've run out of time.
Oh yes. Let's check with Ms. Ngema. If it's ready to come in, and also the state law advisor.
Greetings, Chairperson and the members in the House. It is Phumelela Ngema, the parliamentary state law advisor. I hope I am audible, Chairperson.
Chair, may I be excused at this point?
Yes, Ambassador, you are audible, Ms. Ngema.
Thank you, Chairperson. Chairperson, perhaps before I detail into what I may have wanted to speak to, perhaps it may be fair and correct for the Chairperson and the committee to allow the department to respond to everything and the members to take their questions, because I think, Chairperson, as we understood on the agenda, today was meant for the department to give their responses into the proposals of the submission as well as of the mandate. So on our end, Chairperson, we have not, and it would have been easier if we had had a meeting where we have consensus between ourselves and the state law advisor and the departmental advisors, Chairperson. So I am feeling we might hamstring the process if we squeeze into talking to issues while the department has not covered everything and while we have not had a chance to meet, Chairperson. I don't know if I am interfacing wrongly by asking if that cannot be the case rather than us coming in. Otherwise, if I were to speak and considering the time, I'm going to make generalized points into the submissions and what the provincial mandate had already presented, because we did try to do individual preparations, but we have not come together so that we have consensus as the three supporting system for the committee in this regard and in respect of the responses. I'll be guided by the committee and yourself, Chairperson, in that respect, and my request.
I think the way forward is quite helpful, Advocate Ngema. Let's allow Advocate Naidu to continue, and then we'll then allow you an opportunity with the state law advisor and the department then to consolidate, because it makes things much more easier for the committee when the support system is on convergence. So I highly appreciate that way forward. Advocate, platform is yours.
Chairperson, I have my hand up.
Okay, Tim.
Thank you, Chairperson. Chairperson, I don't know if this is an appropriate time to raise the issue that I raised right in the beginning of the meeting, seeing that we're dealing with mortgages. And so, Chairperson, if I could just refer you to the document that Advocate Naidu referred to, was his
your volume, Tim.
I do apologize, Chair. I do apologize, Chair. Is that better?
Can you improve again?
Chairperson, is that better? I'm speaking right.
That's great. That's great now.
Okay. All right, Chairperson, the document that I'm referring to, which is the document that was submitted.
You have disappeared again.
Oh gosh, Chairperson, is that any better?
Can you improve again?
Oh, gee. Okay, Chairperson, is that any better?
Yes.
Okay. Chairperson, Advocate Naidu would be familiar with his own document, and I'm referring to paragraph 98 of that document, which was a lengthy discussion on the expropriation bill. And perhaps Advocate Naidu can take us through his paragraph there, where he says, it would be useful to get more information from creditors on the kind of real security typically used to secure agricultural loans, about which the public and organizations representing the agricultural industry in particular have expressed considerable anxiety. And that was in our content advisors, that was interpreted as a recommendation that we have a further engagement with creditors, mortgagees, especially on agricultural loans.
Okay.
So maybe Advocate Naidu can speak to that now at this point, and whether that was a recommendation.
Tim, I think you are taking us back to a point when we were beginning. Let's allow the advocate to finish the responses to the clauses. Remember what Mr. Marcus said at the beginning, that he will come together with the advocate and then they will come back to us.
Chairperson, I agree. I just thought it was opportune because at this point, Advocate Naidu has just dealt with this issue of mortgagees. That's why I'm raising my hand at this point.
Yeah, no, I think he'll flag it, and then definitely you'll have an opportunity to deal with that.
Thank you, Chairperson.
Thank you, Honorable Bratasa. Advocate, you can continue.
Chairperson, you have such faith in my unfailing energy and ability to continue. Thank you.
No. Advocating Ngema and the state law advisor. I think the way forward was quite helpful to the committee. Thank you.
I think Ms. Ngema owes me a drink.
I apologize, Advocate.
All right, let's get back to our screen. Okay. We were on clause 12. Just as an aside, I mentioned clause 12.1 earlier to you, Chairperson, and you took a note about amending it to refer to persons with interests in the property. That would account for anyone with a real right in the property who is not otherwise an owner or a holder. So persons in whose favor a general notarial bond or a special notarial bond have been registered, or a person who holds a pledge would be covered. The Honorable Brauthisets, I hope I'm pronouncing that correctly, query relates to 12.1, but also to clause 18 and beyond, where special provision is made for mortgagees, but not for holders of other real rights. And I think perhaps we can flag that when we get to clause 18. So I don't believe that this is correct. The bill does provide for engagement with the holder of a mortgage. They are required they must receive notice of the expropriation and the amount of compensation offered. They may refer the matter to court. They must receive notice of expropriation. If there's a dispute between the mortgagee and the debtor, then that dispute payment will be made only once that dispute has been resolved. If the dispute has not been resolved, then the expropriating authority may pay the money to the master until the dispute is resolved, and then the disputants between them can agree to can get the money from the master, perhaps by agreement or order of court, whatever the case may be. But it's wrong to say that mortgagees are excluded from engagement. I've also addressed in the note that I had circulated that Section 25 of the Constitution did not need to be amended to allow for nil compensation. The counterfactual that I postulated earlier, where it would have been just and equitable, I think, for an expropriating authority to pay nothing, applies under the current wording of Section 25(2)(b). It doesn't need amendment. And so the proposition that the absence of an amendment precludes no compensation is without foundation. Section 12.1 suggests that market value be defined. Market value is not defined at the moment. The Property Valuation Act refers to market value when dealing with property that is to be expropriated for land reform purposes, I believe. I'm just bringing up the Property Valuation Act. Bear with me, please, Chairperson. And it too does not, it does define market value. I beg your pardon. Let me put that on screen. Chairperson, this is the Property Valuation Act. in section 1 of that act, there is a definition of market value. With the necessary changes, it could work. It could be included in the expropriation bill. Obviously, the reference to section 12 will need to be updated, but the definition is a good one. Whether the committee wants to include it is a policy matter, but I don't see any legal impediment to including it in the bill. Moving on, clause 12.3, that's the nil compensation provision. The Eastern Cape Provincial Legislature proposes an amendment. They seek removal of the words including but not limited to, and replacement of those words by which include. I think it's, while the current formulation is quite wordy, I think there's no real difference in substance. The Gauteng Provincial Legislature wants clause 12.3 removed in its entirety, on the basis, I suppose, that it does not believe that nil compensation is ever just and equitable, could ever be just and equitable. I don't think that's correct. And removing clause 12.3 wouldn't change the fact that nil compensation is permissible, notionally, if it's just and equitable. In terms of section 12.1 of the bill, read subject to section 25(2)(b) of the rather section 25(3) of the Constitution. And
Chairperson. If I may, Chairperson, Advocate Naidoo still got the Property Valuation Act up on the screen. If you could change.
Yes, Tim.
I've just noticed that the Property Valuation Act is still up on the screen. If you can just go back.
Oh,
to
yeah. Can you take it down, Advocate?
Sorry.
Thank you. There we go. Thank you.
Sure, thank you. Sorry. Okay, so
at least someone's paying attention, Advocate Naidoo.
Yeah.
Thanks, Tim.
Thank you. So I've covered 12.3, the Eastern Cape Provincial Legislature's comment. I've just responded to Gauteng Provincial Legislature's comment. I'm now turning to KZN. KZN Provincial Legislature recommends that clause 12.3 be amended in its entirety to say that it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances and having been valued as such by the courts. Now, this is interesting because neither of these two elements, having regard to all relevant circumstances, one, and having been valued as such by the courts, two, is new. The bill does provide for all expropriations, and rather all compensation, contemplated, offered, agreed on, or decided by a court to have regard to all relevant circumstances. And the bill currently provides that if there is no agreement on an offer of compensation, the question of the amount of compensation must go to court before any decision is taken. So the amendment adds nothing, but removes much. So I don't think it should be supported. Northwest Provincial Legislature has a problem with clause 12.3a. That's really where the land is lying fallow, and where the land could be put to a socially productive use but is not. The land is not being used to recuperate from farming with the intention of later use. It's not being used with the intention of subsequent development into housing or into some other development. It's simply being held on to for an appreciation in its market value. And what that does is from a social perspective, it sterilizes that land in the sense that nothing from that land is going to directly or indirectly benefit the public. And that's something that the bill regards as a relevant consideration. No more, just a relevant consideration, but a relevant consideration of significant enough import to warrant express mention in clause 12.3. It's not determinative. It doesn't mean that in every instance, when land is not being used and is simply being held on to for market appreciation, that it will always be just and equitable to expropriate for no compensation. No, obviously not.
Advocate, is it impossible to increase the pace so that at least by 1 o'clock we are done?
I beg your pardon. I will try. So the answer is this concern, as with many of the others, stemmed from a misconception that clause 12.3 lists instances in which it will always be just and equitable to expropriate for no compensation, which is plainly wrong. And it also seems to rest on an unfounded assumption that nil compensation will necessarily be paid without agreement and simply through a decision of the expropriating authority without recourse to the courts. And that's false, because if there's no agreement, the ultimate arbiter on the amount of just and equitable compensation remains the court. So not only will the expropriating authority apply 12.3 when making an offer of compensation, but a court, in the absence of agreement, will also apply 12.3 and the factors there in determining whether nil compensation is appropriate. It will also apply 12.1. So I don't think that this concern by the Northwest Provincial Legislature has substance. Similarly, the removal of certain clauses which the Western Cape Provincial Parliament proposes won't get around the fact that it would still be permissible to expropriate land or expropriate land in the public interest in the circumstances which they propose be deleted from the bill. I think this comment is covered by my general statement. This comment is also covered. This is also covered. No, this is an important comment, actually. Both Gauteng and the Eastern Cape Provincial Legislature say that where an owner no longer has control over the land, it may be just and equitable to expropriate that land for no compensation, only if that owner has abandoned control willfully, not where that owner has lost control through no fault of its own and against its will. Consider the situation where a building in the city becomes overrun with unlawful occupiers. the building was once lawfully occupied, and now the number of people in the flats have increased exponentially to a number that's simply not sustainable and not lawful. The owner has lost control of that property. The property is in the middle of the city. It would serve an eminently useful public interest, a public purpose. Rather, it would eminently be in the public interest to expropriate it to be used for housing in the inner city. But that owner hasn't relinquished ownership of the property. It hasn't abandoned the land. It simply lost control because the building has become overrun. And so it would not be wise for the bill to say in such broad terms that it is generally an indicator that abandonment of land by failing to exercise control over it would be an appropriate circumstance to consider nil compensation. So I agree with that. The committee might also consider negligently failing to exercise control over the property. No, let me correct myself. The problem with introducing an element of willfulness is that to sustain this as a ground on which property is considered for expropriation for nil compensation, the expropriating authority or the court must be satisfied of the owner's subjective state of mind. It has to be willful. And it may be very difficult to get evidence to prove that. Well, the owner could have run away, could be overseas, might not care about the property, might not be traceable. So it might be that there is evidence to rebut willfulness, but the court still need it. This is no less a relevant factor to consider, no less weighty factor. So perhaps a better formulation would be, despite the owner being reasonably capable of exercising control, that would not turn on the owner's actual capability, but only on the owner's reasonable capability, which is an objective standard. It doesn't turn on evidence that is peculiar to that owner. Um, 12.3d. I've referred to an example where a beneficiary of land reform could be expropriated because the land is not being used for the intended purpose, for the land reform purpose. I think there's merit in this. This is a good point. 12.3d. Just because property is being used unlawfully shouldn't mean that the property shouldn't be enough, shouldn't be sufficient to consider the property for expropriation for nil compensation. Because, of course, the remedy for unlawful use is enforcement of the laws to either regularize that use or to prevent the unlawfulness, to ensure that the use is brought in line with the law, not to take away the property. Because if that was so, it may be tantamount to forfeiture, which is not the object of this bill. So I do think that the committee should consider reformulating E, paragraph E. 12.5. This 12.5 would be considered under 12.1 if my recommendation on the amendment of 12.1 is accepted. Clause 13 deals with interest on compensation. The date of interest, I don't know what the answer is. This is a policy choice, not a law choice. Of course, you can't have interest on something that isn't due, and the due date would be the date on which the compensation sum becomes payable, or on which another amount of compensation, for instance, for reasonable maintenance of the property, becomes payable. So I'm going to dodge the answer because I don't know what it is. Damages for losses. This reasonable moving costs, the cost of relocation, possibly even the loss of goodwill if a business is expropriated, are relevant factors that should feature under 12.1. The committee might want to list these as specific factors, as weighty factors, just as the bill lists the weighty factors in 12.3 as factors that might point to the appropriateness of nil compensation. Whether the committee includes them as express considerations is a policy choice. 13A. I'm sorry, Chairperson, did you say 12:30 or 1 o'clock?
No, you can proceed until 1 o'clock, Advocate. Because we want to do justice to the department in terms of its response to the issues canvassed during the negotiating mandate.
Thank you, Chairperson. I may continue, but I'm not sure whether I can. I might run out of steam.
Okay.
13.3. Yes, this depends on the date on which. This is a very good point. A very good point, I think. If there's a dispute as to the amount of compensation, then the expropriated owner, which is a VAT vendor, cannot render a tax invoice to the expropriating authority. If it can't do that, then it won't be able to claim interest in that period. But then again, no one would be able to claim interest in that period, regardless of whether they're VAT vendors. May I suggest, and this is just off the top of my head, that interest on an amount of compensation might run from the date on which it could reasonably be expected the owner would accept the offer if it is ultimately upheld by a court. I'm sorry, Chairperson, I'm going to have to give this further thought. This is quite complex. Yes, I've noted in my written advice that given the systemic failures of the post office, the committee should consider carefully whether prepaid registered post should be an authorized means of service, correspondence, and in this case, payment. I do think that clause 14.1, which deals with particulars, is sufficiently particular. I'm not sure whether replacing the word reasonable with this longer sentence adds much, because those matters should already have been dealt with in the notice of intention to expropriate in 7.1. Yes, in 7.2. And 14.1 permits requests for particulars about the amount of compensation in respect of any matter of in respect of any offer which would have been made in a section 7 notice, a clause 7 notice. Chairperson, I have given written advice on whether counter offers should be included in the bill. I think this is a policy choice, ultimately, whether Parliament wants to include a further step. And if the committee decides that it does, I think I did provide suggested language. Clause 14.2, the comment on clause 14.2 is that the affected person might not have the wherewithal to approach a court because it is so costly. I would refer to clause 19, sub 3, which permits a person who would otherwise not have the skills or money to approach a court to determine a just and equitable amount of compensation, to request the expropriating authority to institute the legal proceedings. So the expropriating authority will bear the costs initially, and then when the court makes its decision, it may make an appropriate order as to costs. If the court finds, for example, that the affected person's opposition to what was reasonable compensation, reasonable offered compensation, the court may decide that the expropriating authority should not bear the costs of the legal proceedings, but that the expropriated person should bear those costs. But that's a matter that falls entirely within the court's discretion. So I don't think that the fact that litigation is expensive is an insuperable bar to persons who would otherwise challenge the amount of compensation offered. The bill has a special mechanism to cater for their rights of access to court. This is the concern raised in relation to clause 15.3 by the Eastern Cape Provincial Legislature is important. I think it merits further consideration. It provides that any delay in payment of compensation by virtue of subsection 2, which is a dispute I beg your pardon. Yes, which concerns disputes on potentially between a mortgagee and an owner, property rates, and where money is deposited with the master because of non-agreement or perhaps someone cannot be found, then that dispute will not prevent the payment of compensation to the expropriated owner or expropriated holder, or any other dispute arising will not prevent the passing of the right of possession. I'm not sure that's entirely correct in view of the amendment to clause 19(6), which allows for any party to approach the court at any stage on any matter relating to the application of the Act, because that party may want to interdict the expropriation proceedings, and the court should not be deprived of that power. That would probably be unlawful or unconstitutional. Oh, I see. I'm sorry. There was an amendment made to clause 15(3), a qualification, unless a court orders otherwise. And that was to account for this very problem. So I think we are covered. The Gauteng Provincial Legislature is of the view that the right to possession can pass before the payment of compensation. That's not correct. If there's a dispute about the amount of compensation, then the right to possession cannot pass because expropriation can't happen unless expropriation occurs in urgent circumstances. And outside urgent circumstances, payment of compensation precedes the right to claim possession. So I'm not entirely sure I understand the concern, or that the concern is based on the right premise. I may be mistaken, and perhaps the Gauteng Provincial Legislature could explain. And the Western Cape Provincial Legislature raises the same concern. Clause 16(1). I referred earlier to the possibility of property having become subject to... I'm sorry, if you could excuse me for a moment. I'm just going to... There's someone at my door. I'm so sorry for this.
Well, advocate.
Thank you. All right. So I've already dealt with the possibility that even in the ordinary course, outside the context of expropriation, a mortgagee might not get the full value of the outstanding indebtedness. And so too, there can't be any guarantee in the context of expropriation that the mortgagee will always have the outstanding indebtedness settled. It will depend on the facts. And the Western Cape raised the same concern. I'm not sure what the answer is regarding the clearance certificate, but I would imagine that the clearance certificate, I stand to be correct, but the clearance certificate would be required for transfer from person A to person B by consent. Whether expropriation would require a clearance certificate might be superfluous if the expropriating authority has already done the homework. In other words, has already received the relevant information from the municipality about outstanding rates and charges to the property, or yes, so it might be superfluous. Again, I've addressed the fact that transfer is a misnomer when it comes to expropriation. Expropriation is an original form of acquisition. Ah, 17(4)(c) raises an interesting point which was debated at length in the NA round. It provides that after expropriation, the expropriated owner remains liable for rates and other charges levied on the property until the right to possession vests in the expropriating authority. If the committee recalls, I mentioned that after expropriation, there is a window period in which the owner who has been expropriated retains possession of that property. And in that time, that owner can make alternative arrangements. For so long as that owner has possession of the property and use of the property and the benefits of the property, they are almost in as good a position as owner. And so whatever charges they incur from using the property, which attach to the property itself, should be for their account, not for the expropriating authority's account. That's really what section 17(4)(b) is getting at. And that seems fair. Of course, the committee could decide otherwise, but I don't see a legal problem with that. Clause 18, deposit with compensation with the master. This is the point I've mentioned several times before. Should the expropriating authority be liable to pay the difference between any compensation amount and the outstanding amount owed on a bond which attaches to a property? And I don't think, I mean, it would be something to be answered on a case-by-case basis. As I should also mention that any outstanding value of any outstanding amount on a loan is something that should be considered at the clause 12(1) stage when the expropriating authority is considering all relevant circumstances. Clause 19(6). The provision of legal representation at state expense is something that I think would require input from the Justice Department. I don't think this committee can make that determination on its own, and it is a policy choice in any event. 19(8). This was a good point. Perhaps I can explain how appeals work in general and then deal with how appeals work under the bill. When one goes to court for the first time, and the court makes a decision. If the decision is against you, let me use you. If the decision is against you and you want to appeal, you want to challenge that decision in a higher court, then you can ask the court which made the decision for permission to approach a higher court. It's called leave to appeal. Leave is permission. Once you ask for that permission, the effect of the order that the original court made is suspended. Suspended pending the outcome of the application for leave to appeal, and if leave to appeal is granted, the outcome of any appeal. I hope that makes sense. So you've got little court, you've got big brother court. If little court makes a decision that someone doesn't like and that person wants to go to the higher court, the idea is that they don't want the order of the lower court to be enforced while they are disputing the basis on which that order was made in another court, because by then it might be too late. The right might be rendered, might be gone, or the facts may have changed. Now, what the expropriation bill has is a very elaborate process which involves the courts at different stages. Courts must be approached to determine the amount of compensation if there is no agreement. Courts may be approached at any other stage to deal with any other dispute arising out of the act. That could be before the decision to expropriate is taken, or after the decision to expropriate is taken, or when the issue of payment arises, possession, whatever. Clause 19.6 allows that. So you've got a first-tier court which will deal with, let's call it compensation and or any other decision. If that court makes a decision which the affected party does not like, and the affected party refers to a person, so I don't think it's debatable whether an expropriating authority is a person, but let's accept that at the very least a person is a person facing expropriation. Once that first-tier court makes its decision, that person can apply for leave to appeal to a higher court against that decision. Ordinarily, lodging the application for leave to appeal will suspend the court's decision on compensation, and it would not allow the expropriating authority to proceed with the next step, to take the decision to expropriate. If the committee will recall, clause 7.6 of the bill says that the expropriating authority may take the decision to expropriate only after compensation has been agreed or determined by a court. So if leave to appeal is lodged, then the expropriating authority can't take the decision. And the thinking was that if one court has already found that the amount of compensation is just and equitable, that should be good enough not to stymie the process. The affected person can still go on appeal if leave is granted, but the effect of doing so would not bring a halt to the expropriation process in the ordinary course. But that person, in applying for leave to appeal, could also ask the court to make an order that halts the expropriation process. It's an interdict. But the standard for getting that interdict is higher than merely lodging an application for leave to appeal, regardless of the merits of that application. The person affected by an order of court which says that the compensation amount is a positive amount and is just and equitable, and the effect of which is to allow the expropriating authority to proceed with the decision to expropriate, should not be permitted to lodge spurious appeals, which would stop the process. So to get an order that would stop the process pending the outcome of an appeal, that person must satisfy the court granting leave that there are compelling prospects of success on appeal. That means that that person needs to explain to the court granting leave why they believe that court got the decision wrong, whether it's a matter of law or a matter of fact, whatever the case may be, why there are reasonable prospects that a higher court would find differently. And that's the test for leave to appeal. To get the interdict, that person would have to go further. They would have to show that the grounds on which they seek leave to appeal are so strong that they make out a compelling case. So they can't just bring grounds of appeal that would merely have sort of equal probabilities or are just arguable. They must be compelling enough to get the interdict. And that means that in cases where there is real doubt about the correctness of the first court's decision on compensation, the expropriation should be halted if a proper application is made out. All right, so turning to the comment, what the Eastern Cape Provincial Legislature wants to do is reverse what the bill does to bring it in line with the position under the Superior Courts Act. That's the default position that I explained to you. One, doing that would defeat the object. It would allow litigants to stop an expropriation, to stop an expropriating authority from deciding whether to expropriate simply by lodging an application for leave to appeal without more, regardless of the grounds of that application. And two, it would perhaps ignore the fact that an independent authority has already expressed a considered view on the matter. This is not, the first instance has already come and gone. Three, it also ignores the fact that if the default position were to be followed, then there's no need for a special clause in the bill because the provisions of the Superior Court Act would automatically apply. So I don't think the Eastern Cape Provincial Legislature's comment, their suggestion, has merit. Gauteng seems to be of the view that 19.8 allows expropriation before the amount of compensation is agreed or determined. 19.8 says, 19.8 is the provision we've just been discussing, sorry. I think that the Constitution, which requires section 25.8, so I beg your pardon, which requires in terms of section 25.2b that in the case of non-agreement, a court must make a decision on the amount of compensation, will have been satisfied if at least one court makes the decision. It will have been satisfied if at least one court makes that decision. It doesn't necessarily follow that a final decision by a court of appeal needs to have been made in order for section 25.2b to be satisfied. It's not clear. I'm not saying that this is 100% correct, but it's arguable. The next point is a very interesting one, and it's one on which the department made extensive substantive submissions to the NA Portfolio Committee on. What happens if the expropriating authority... Oh, I'm sorry. I'm thinking of a later clause. My mistake. The Western Cape Provincial Legislature recommends that where property is expropriated on an urgent basis for temporary use, that property, possession of that property, should be restored to the owner if and before the expropriating authority takes a decision to expropriate it permanently, for permanent use. That seems very impractical, but also I'm not sure that the notion that it would deprive an owner of bargaining power has any force, because the owner never has any bargaining power in the context of expropriation. Expropriation isn't about consent, but the owner's interests must be taken into account when the amount of compensation is determined. And the court has the final say on that where there's no agreement. So I think the Western Cape Provincial Parliament, with respect, has got it wrong, has got the premise wrong. Here, this is the comment: where property is taken for temporary use, there's a realistic expectation that it will be returned. I don't think that necessarily follows, but it's a possibility. It's a prospect. And the second is government should not be allowed to negotiate from a position. Well, government's not negotiating; it's expropriating. So that concern is based on a false premise. Clause 19.9 from KZN. They propose that...
Advocate, is there any, yes, just if you can just wrap up, because now it's almost 1 o'clock.
Thank you, Chairperson. I'm going to agree with this as the last point.
Yeah, I think we're only left with 4 clauses. Maybe in a nutshell, we can just wrap them up, yeah.
Thank you, Chairperson. 19.9, whether the state provides for the cost of legal representation as a policy choice, which I think will entail engagements with the Justice Department. Clause 20, urgent expropriations. It might be that urgent expropriations do need to be overseen by the judiciary. But that, again, I'm not sure is legally required by the Constitution, but it may be desirable. It may be desirable. I'm just checking. Chairperson, there's a lot more to cover, but what I have done is included my comments in the bill. So I think it's pretty self-explanatory, and many of these comments refer to what I've already said above, or what I've already said in the written note. So I don't think it's necessary for me to repeat that orally now. May we therefore end the submission, the oral presentation here?
Thank you, Advocate. It was indeed a marathon. It was indeed a marathon. You are correct. Indeed, I think we must take this opportunity to really express a word of thanks to yourself and also the department for engaging your expertise in terms of navigating through this through this difficult environment, and you were able then to put us in a much more better position to give context to critical proposals and issues that were canvassed during the negotiating mandates. Like as Advocate Ngema has indicated, the department and the state law advisor will find time to then ensure that they converge, and then through their readiness with the committee, they will then communicate to the committee secretary, so that we are then able to see as to whether by next week Wednesday we'll be able then to finalize. But I think as the team indicated, there is one area that Honorable Prater said as raised. So it will be important also from the department side next week when we meet, because we'll try to see as to whether through the House Chair we are able to get an opportunity to then finalize this leg, and then probably through that we'll then be able to get also your interaction with the department in relation to the issue raised by Honorable Prater. But I think what is quite critical is that as the committee we have not taken a decision. We have not taken an offer to extend another round of engagement with the banking sector. But I think what is critical is your interaction with the department, so that there is a clarity of thought around that, so that Honorable Prater is cleared on that issue. But I think what is critical is the fact that you have put us in a much more better light to understand angles from where the department and the legislature, from where the legislatures concrete proposals, clause by clause, are coming from. We are more enlightened now. Thank you, Advocate.
Thank you very much
for your opportunity.
Chairperson, if I may say, I will be in court in George outside Cape Town, so I will not be available to assist the department on the engagements with the state law advisor and the parliamentary legal advisor. Unfortunately, I'm not sure whether that might be a factor in the committee's timetabling, but if it is, I would be very grateful.
No. I think it will not be a critical aspect, because we have helped us a lot. I think what will be quite critical is probably between now and Wednesday, the department will see. We'll find a way to interact with Ms. Ngema and also the state law advisor, even when you are not there. But we have really done wonderful job in terms of your presentation for the last 3 angles that we have been with you. Thank you. Thank you. Honorable members, let's then take this opportunity to agree that the other part. Yes, Committee Secretary.
There is a hand. As
The state law advisor, Chairperson.
Okay.
State law advisor, Van Breda. Let's give you, and then we'll then give over to Tim.
Thank you, Chair, and honourable members. Chair, I would just like to gain some clarity regarding the process the committee will follow hereafter. Chair, I do note that according to the committee's program, the final mandates meeting will be held on the 6th of December. And Chair, you did indicate earlier that there will be a meeting next week. And as you know, the parliamentary advisor and I, together with the department, will have to reach some sort of consensus in respect of proposed amendments to the bill, which will, of course, be a time-consuming process. Chair, what I require clarity on is the expectation, Chair, that a C list reflecting proposed amendments will be presented at the next meeting? Chair, if that is the case, furnishing the committee with a C list at such an early stage would not actually be possible. I think the parliamentary advisor can vouch for that as well. further to that, Chair, there must, of course, be consensus by the committee in respect of any proposed amendments. So what I'd like further clarity on is it the committee's expectation that a C list will be presented prior to the committee reaching consensus on proposed amendments? I would just like some clarity regarding the way forward. Thank you, Chair.
Thank you, Mr. Van Breda. The committee relies wholly on your technical expertise and the parliamentary legal advisor on your readiness. You are correct. We would want to finalize the matter, but what we do not want is to gloss over the work, such that you are then able to ensure that as the committee, what we received from yourselves, what you received from Advocate Ngema, there is no question mark in terms of the quality of the work. So we will definitely rely on yourself. Let's agree that you'll interact with the committee secretary, so the committee secretary will engage with us when the team is ready. Does that suffice, Mr. Van Breda?
Yes, Chair, I think that will suffice. I think we do need another week to actually consult each other and come up with a proposal or consensus in respect of amendments. So perhaps we'll probably be ready by the week after next to make some sort of presentation, if that will be agreeable to you, Chair. Thank you.
Yeah, no, it's fine. Look, like as you said, we rely on the committee secretary will indicate to us when the team is ready on the C list. Thank you.
Thank you,
Committee
Chair.
secretary, can you come in?
Thank you, Chairperson and honorable members and colleagues. Chairperson, I think it will be important for this meeting or the committee, to take a decision, as to when at least, they are going to meet. Not that at least, ourselves as the team, as the officials, then at least, decide. Because this is got the implications, Chairperson. So if the committee then at least, agrees, to the proposal, then at least we'll take it from there.
Yeah.
But the suggestion is that maybe to meet on Wednesday, the 29th, from what I'm picking up from Mr. Van Breda, is that they won't be ready. But maybe I can also put to them, try to check Friday, the 1st of December.
Mr. Van Breda?
Chair, I cannot agree. Sorry, I can't confirm or guarantee that we'll be ready by the 1st, but we will liaise with the secretary and let him know how far we are. If that's okay with you.
Let's agree on that. You'll guide us, and then we'll then move forward. Honorable Bratazef?
Chairperson, thank you. I'm partly covered by Mr. Bradar. That was also my concern. But also then once the state law advisors have done their job, then obviously we'll have to also circulate that information back to the provinces, am I right, for them to come up with their final mandate. So they'll have to consider everything that we've discussed today and the recommendations of the department. So that's also just something to factor into the process.
Indeed. No, thanks, team, for that. Honorable members, let me then take this opportunity together with our guests, the state law advisor, the parliamentary legal advisor, Ms. Ngema, the advocate, the department led by Mr. Make, representative from our legislatures, and our honorable members and the parliamentary staff, to extend a word of gratitude to all of you it's quite a delicate bill, but indeed what is quite important is for us to make sure that there are no shortcuts. And as a result of that, it makes sense for us to be able to adjourn at this point in time. We would want to finalize the matter, but let's allow the team then to prepare themselves, and then when they are ready, they will indicate that to us. Thank you, honorable members. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Chairperson, can I
Yes.
request the staff to remain, Honorable Dr. Clark, Ms. Ngema, and yeah.
Thank you.
Mr.
I think they got your message quite clear. Thank you, Committee Secretary. Have a wonderful day.
Thank you, Chair.
Mr. Mtilene, don't
Recording
keep us
stopped.
No. It won't even take 5 minutes.
And our bodies are sore.
I know. Actually, this can I request parliamentary streaming also not to stream this discussion? And Mr. Siabonga Nkibe, I don't know. Thank you. Parliamentary streaming.